action taken report was to be filed within a period
Yes.
of 3 months.
Yes.
That is why this follow-up letters
Yes.
and all these
Yes.
things is happening. This is what you have prepared?
Yes. One is list of date and another is adverb, remark and aspersions in which page, what line, that is against us. I have highlighted that.
1 मिनट जरा इसको डिसकंटिन्यू करो एक बार इसको डिसकंटिन्यू कर दो
Yes. If my lets me go through that adverse remark.
Yes.
First, page 97, first line on top is after encroaching forest land. And we have taught on record that
Page number
there-
97, adverse remark and aspersion.
Yes, 97, that is the impugned order,
Okay.
which is under challenge. Each and every line of that order, which is without hearing us, is observed, that is alleged. And that starts from page 96.
You had also filed a writ petition before this court, challenging at one stage.
Lokayukta's proceeding.
Yes.
I was not aware. I have categorically stated in my application.
No, there is one writ petition. Just a moment. This is WPC number 2033 of 15.
Double of 15, that is not connected with this proceeding.
Page 110.
Page 110.
No, this is not connected with this proceeding.
Page 110 of page 110 is impugned order.
323. We are taking up the record of 32338. This is in connection with Pollution Control Board.
Yes.
Perhaps. Now there is one more order. Yeah. All right. Okay, so whatever proceedings you had undertaken before this court were primarily relating to your clearances by the Pollution Control Board.
And some forest cases which are caused by the High Court any encroachment.
So your main ground is that impugned order has observations as well as directions which directly affect you.
Yes. Yes. And that was made without impleading us as a party, without giving us any opportunity of hearing. And the prejudice, what we are saying, that it has causing far reached loss to us, that each and every authority in garb of this order, there are problems with us.
So, if that be so, you say that you have not been heard in the matter, and therefore the matter should be remanded according to.
As remand will not will be, my submission will be in accordance with law, because that amounts to confer jurisdiction to authority which they doesn't have. Because now my grant of CTO, which was granted at that time by virtue of
No, therefore,
he doesn't have
apart
authority.
from that, this would be the last relief which, this will be the last alternative relief
And
which you
that
can think of.
that I am saying, madam, that will amount to confer jurisdiction, which otherwise Lokayukta doesn't have.
So, what
How
is,
can a Lokayukta, office of Lokayukta can observe that I am an encroacher when the High Court paused that PPA?
no,
proceeding?
it is on the merits. When you say that the Lokayukta did not have any jurisdiction at all to entertain the nature of complaint,
Yes.
right? So you have to demonstrate that
Yes.
that Lokayukta had no jurisdiction to entertain the nature of complaint.
Yes.
And if we also say that all the points regarding assumption of jurisdiction by Lokayukta vis-a-vis the petition that they had filed will also remain open, because then we have to scrutinize the complaint and then give a finding that whether this complaint is actually maintainable, not maintainable. Then the complainant is also not before us.
Yes.
Who is the complainant? Are you for the complainant? Okay,
The-
complainant is before us.
For the redressal of grievances which was raised before the Lebanon Lokayukta, the complainant has also went to the
You see, this
NGT.
is on merits.
That is also dismissed.
This is also merits. This is also on merits. If it is just like quashing of FIR, right? If on the face of it, the Lokayukta did not have the jurisdiction, then only you can argue this. Otherwise, if it is to be if something is to be placed on record, then under such circumstances you have to place on record before the Honorable Lokayukta only.
That's fine. Even if I can demonstrate before this honorable court that even if that was not placed on record before the learned Lokayuk does not have jurisdiction on all those issues. And
Let
for
me hear
that,
your senior.
if
आप बहस करें. You see, as far as subject to what respondents have to say, observations and directions will directly affect you, right? Without hearing you appears to be violation of natural justice,
Yes.
right? Then one option is that we remand the matter, set aside the order, remand the matter with 2-3 kind of observations. One is that during the pendency of this case, you are also, since we are aware of all the proceedings, much water has flown,
Correct.
right? Then that would, you can bring it to the notice of the Honorable Lokayuk. This is one thing. There could be certain allegations from your part that certain orders have not been placed, or certain developments which were otherwise taking place were not placed because you were not party, you had never had that opportunity. So we'll give you that opportunity.
But that in my submission words would not be required because today the petitioner applicant before the lokayukta has not made any prayer for impleading. Now to send back the matter.
No, he has not made any prayer for impleading,
before
but
the
you are aggrieved by it.
So if I am aggrieved by it, it's my submission, it's a nullity. Any observation finding given behind my back is a nullity, right?
No,
That is
it can't be like this, because if there are certain allegations, right, whatever be it, and if any observations, directions, etc. has been passed, then under such circumstances it does not become a nullity because the person is not there. He has an opportunity. He has an opportunity to present his case. He should get an opportunity to present his
But
case.
he can't. I cannot be a subject matter of a proceeding before lokayukta.
Yes. So you just satisfy us on that point.
Correct.
That your conduct. You see, there are two things. There is a public servant.
Correct.
Who is not undertaking his responsibilities as per law, and due to which he is giving certain benefits to Mr. X.
Correct.
Then under such circumstances, do you want to say that Honorable Lokayuk will have no jurisdiction to entertain any complaint against such kind of a public?
100% he will.
Okay.
If there
Then
is
under such circumstances, the Honorable Lokayuk will have to adjudicate on the point as to whether the public servant has actually performed his duties as per law or not, or he is involved in some kind of other additional things.
Correct.
Right? And while doing so, he will have to scrutinize the records, and then he will come to a finding that he has given undue benefit to somebody at the cost of beyond the procedure of law or whatever.
I can
Right.
satisfy your observations on that.
Then under such circumstances, those findings are only incidental.
If your lordship comes to the order which we have challenged, I'll show page by page what affects me.
I have read it.
So your lordship will quickly.
I have read it. I have read it, and I find that there are certain observations, certain directions which are going to, yes, which are going to directly affect you.
What I am trying to say.
I am only on the point of remand. You say that this cannot be remanded, so please satisfy on the point of remand.
I will do that. Kindly allow me to place plus 102 first. Just what is affecting me is very simple. Nothing more, nothing less. The solution to this is, according to me, a simple solution. Page 102. Yes, this is I have carefully gone through the first line, last 3 words. I have carefully gone through the entire record. The document placed before me, the show causes with its annexures submitted by the chairman and member secretaries of the board, and after perusing the same, the following facts have surfaced. I am straight away requesting Lordship to come to 3. Electrosteel integrated in course of installation of its unit encroached forest land. This is one which is hurting me. How this finding. Similarly, 4. Since the company has encroached forest land, on what basis these factual findings have come? Kindly note. Now turn on towards the next pages. I'll just quickly run through what I am agreed with. Now, Lordship will come to page 109. My point is para 14. Now the question arose whether the then Member Secretary Mahendra Mahato board has properly considered the issue. The direction of the Honorable High Court given in WPC number so and so was only to the extent that the company shall be given opportunity of hearing, and this was the demand of national justice. No specific direction was given to issue NOC C2 in favor of the petitioner company. The Member Secretary board was not under obligation, he was not bound to grant CTO, and he had every right under the Act to refuse reject application filed by the company for grant of CTO. It is well within the knowledge of the Member Secretary board that the company has violated the terms under which environmental clearance was granted by the MOEFCC Government of India. In the applications for grant of environmental clearance, the company has mentioned that no government land is involved, no national park, wildlife sanctuary is situated within 10 kilometers radius. Apparently, the condition precedent mentioned in the application is violated. This line. On this score alone, the then Member Secretary should have decided the issue. Now, I am again not submitting these findings that whether the CTO is valid or invalid. The NGT has the jurisdiction and the person concerned went to NGT where he lost. So there can't be overlapping of jurisdiction. Now similarly, kindly come to the next page, page 111. Again, 1, 2, 3, 4, 6 lines from the bottom, your lordship will find it starts with the word department, but the fact remains. 6 lines from the bottom. Department, the word is department, but the fact remains.
Yes.
I am agree with the company has encroached more than 200 acres of forest. Again, this finding.
So there is a finding of encroachment.
Yes, I am only saying that
Just
this
a moment.
encroachment.
Finding of encroachment. And then finding of violation of environmental law.
Now, what is happening is what turns on basis page 114 para 18.
Just a moment.
Yes.
Violation of environmental law. By stating that no government land. So there was a misleading fact which was placed.
Yes, misrepresentation by me while making the application.
Government land. Misrepresentation.
Now, kindly come to what happens is page 114.
Yes, 114.
Para 18. The entire episode has been moving around the encroachment of forest land made by Electro Steels Limited, and this is the root cause for all the events explained in the preceding paragraph. The company, under the garb of purchase of piece of land from the vendor who got decree entitled suit number 2596, has encroached more than 200 acres of forest land, whereas decree entitled suit number so and so was only for a land area approximately 17 acres. In this context, the Divisional Forest Officer Bokaro had taken various steps and lodged cases against Electro Steels Limited. Not only that, forest officials reported the matter to all concerned, but all the steps taken by the forest department were somehow or the other flouted by the company by making misrepresentation before the court and also before government officials. The episode will not be concluded if I would not explain the steps taken by the undersigned during the pendency of the proceeding. The Deputy Commissioner Bokaro was directed to measure the land under possession of Electro Steels Limited from the boundary to boundary, and for that Deputy Commissioner Bokaro was permitted to have the assistance from the Circle Officer Chandankari Block and Circle Officer Chas Block, Regional Forest Officer Bokaro, as well as the Member Secretary Board. The officers of the company were also directed to extend cooperation. This order was passed on 11/4/2017. Now, this is a point which you lordships have to consider. Under which jurisdiction the lokayukta had this power? Number 2. In compliance thereof, a report by letter number so and so dated so and so of the Deputy Commissioner Bokaro had been received in this order that indicates about 250 acres of forest land have been encroached by the company. The office of the Lokayuk took further efforts and issued notice to the Secretary Ministry of Forest so and so while order dated 9/5/17. Although the Secretary did not appear, but Additional Principal Chief Conservator of Forest, Ministry of Environment, Government of India appeared before me on 27/2017. The concerned officer gave assurance that officers of central government would also take steps to get it confirmed whether the company has encroached forest land in course of its installation. The designated officer Shri Rajiv Ranjan, Scientist D Environment, and Shri Vasant Kiran Babu, Deputy Conservator of Forest, Regional Office MOA, CC Ranchi, Government of India also measured scientifically even using Google Map, and the copy of the report furnished by them also confirmed There are about 150 acres of land are still lying within the campus of the company, and the encroachment made by the company finds support. Thus, it is clear that the aforesaid company has violated the terms and conditions and also did not stick of the declaration made by it at the time of making request for the grant of environmental clearance from MOFCC, Government of India. The member secretaries board, for the reasons best known to them, did not consider this fact and took the stand that the board is not supposed to look into the title of the land. On the basis of the discussions made above, I am concluding the order with the following directions and suggestions. Shri Mahendra Mahato, the then member secretary board, and Shri Sanjay Kumar Soman, present member secretary, have and had not discharged their official obligations diligently and carefully, rather they have extended favor to the company for the reasons best known to them. From the discussions made in this order, it is very clear that they have misused their power and position, and therefore appropriate action is required to be taken against the then member secretary Mahendra Mahato and present member secretary Sanjay Kumar Suban. And for that, the copy of this order may be sent to Additional Chief Secretary, Department of Forest, Climate Change, Government of Jharkhand, Ranchi, and he is directed to submit action taken report within 3 months from the receipt of the order. Let a copy of this order be sent to Director General of Police, Jharkhand, and Deputy Commissioner Bokaro with a letter number so and so, with a copy of the letter number so and so dated 2010-2014, addressed to the Principal Secretary, Government of India, Ranchi, and a direction given by the Deputy Secretary to the Government Department of Forest and Environment, Jharkhand, by letter number 521 dated 6/2/15, so that appropriate action from their end may be taken and to submit action taken report within 3 months. Now these two orders were challenged before the High Court. In the so these two orders were stated. Ultimately, my grievance is this: that does the learned lokayukta have jurisdiction to give a finding on encroachment? Even if I am there, I don't have any grievance if there is a finding returned that the officers of the state government have indulged in malpractices. I really cannot have any locus to question such kind of an order. So the first part of the order that you look into this, Mr. Member Secretaries, whether they have done or not, I am not agreeing. Because that is within the realm of affairs that the learned lokayukta can use. Now these kind of scathing observations against me regarding violation of the terms and conditions of the EC or misrepresentation or encroachment, how does it affect me?
Will it suffice if we observe that the observations and directions which have been made at the back of the petitioner, essentially dealing with the environmental clearance and with the possession and title of the property, will have no bearing in any forum where the petitioner might be litigating as a plaintiff or the defendant?
And in law, I cannot expect because of this observation, no proceeding against me cannot be initiated. If any proceeding is initiated against
you will have your own opportunities.
Correct. That is what the Delhi High Court and Delhi Jal Board exactly similar facts.
You will have your own opportunities.
I am saying, Lords, am I immune from any kind of challenge before an appropriate forum? If I have violated the law,
and if the list crystallizes in the judgment of Honorable Lokayukta, then nothing would remain.
Correct.
That should suffice.
Delhi High Court, kindly have a look at this order. Same manner, Lokayukta made observations behind the back of private contractors, and ultimately the matter travelled up to the Delhi High Court. And then, if your Lordship kindly comes to the concluding portion, the second last page, para 16.
Yes.
For the foregoing reasons, I partly allow this petition and direct any part of the report which casts aspersions upon the petitioners related to execution of the work awarded to them by the Delhi Jal Board shall be ignored and will not be taken into consideration by the respondents for any purpose. The respondents will not initiate or proceed to take any action against the petitioner on the basis of the recommendations or observations made by the Lokayukta in his report. This, however, will not in any way come in the way of the respondent Delhi Jal Board to apply its independent mind to take action against the petitioners if they have committed breach of any condition. I think this is
or if the by the impugned order, the one or the other officer has been found guilty of his conduct.
Whatever is open to them in law to do against me, just because your Lordships, if at all, say that this will not be.
No, I will not. I will only say that wherever your litigation or any proceeding,
This will not be
etc.
hindered.
This will not be.
Correct.
This will not prejudice your case
Absolutely
in
not.
any manner. That
So-
should be sufficient.
Absolutely sufficient. Anywhere I go, this should not be shown and say this is a finding.
Yes, this
That
is a
all.
finding and
So
conclusive.
if you want to evict me, please evict me, show that I am in
That's
I am ready. This will not be an evidence of encroachment.
That's
That is all.
yes. You tell us. क्या बोलना है आप लोग को? आप बताइए क्या बोलना है आपको? भाई अगर मान लीजिए आपने टाइटल डिक्लेयर कर दिया, आपने उनको वायलेटर डिक्लेयर कर दिया, तो दैट इज अ कंक्लूसिव फाइंडिंग. फिर ये
मतलब-
टाइटल सूट में क्या करेंगे और फिर ये एनवायरनमेंट क्लियरेंस में क्या
There is
करेंगे?
no question of title suit, first of all, because the entire thing
एनक्रोचर
has,
डिक्लेयर किया ना.
entire thing has come. Madam, may kindly have a look to page 111, 111.
नो I'll come to that.
It
I
is-
hear
it is
you
in the-
भाई आपके अगेंस्ट में सोच रहे हैं तो आपको बिना सुने तो ऑर्डर नहीं
नहीं
करेंगे.
नहीं, मेरा बिना
सीधा
सुने तो आप कभी करती हैं.
इसलिए आप हमको सिर्फ इतना बताइए कि ये जो ऑब्जर्वेशंस है फॉलोड विद द डायरेक्शन आल्सो, राइट? इट इज नॉट जस्ट ऑब्जर्वेशन. उनको रिपोर्ट भी चाहिए 3 महीना में, राइट? सो रिपोर्ट चाहिए, कंप्लायंस रिपोर्ट, है ना? सो अंडर सच सर्कमस्टांसेस द कंप्लायंस रिपोर्ट इज डायरेक्टली हिटिंग द पिटिशनर. Yes or
Compliant
no?
reports to, my lord, it was, direction was against the airing authorities, not against the company.
क्या करता वो एयरिंग अथॉरिटी, क्या करता कंप्लायंस में?
Compliance
Let us
में
read the
इंटरनेशनल
compliance.
करेगा.
Let us-
एक बार देखा जाए उस बात को.
चलिए.
Before my red pen starts, can I just come back?
हाँ, yes, बट यू बी हियर.
I will come back.
Para 20, my lord, page
हाँ.
160. On the basis of discussion made above, I am concluding the order with following directions and suggestions. Mr. Mahendra Mahato, the then Member Secretary Board and Sri Sanjay Kumar Suman, present Member Secretary Board, have and had not discharged their official obligations diligently and carefully. Rather, they have extended favor to the company for the reason best known to them. From the discussion made in this order, it is very clear that they have misused their power and position, and therefore appropriate action is required to be taken against the then members, Secretary Sri Mahendra Mahato and the then member Secretary Sri Sanjay Kumar Suman, and for that, copy of this order may be sent to the Additional Chief Secretary, Department of Forest, Environment and Climate Change in Government of Jharkhand, Ranchi, and he is directed to submit action taken report within 3 months from receipt of the copy of this order.
No
This was-
grievance. They have no grievance against this.
No, one of the
they are-
person, Mr. Mahendra Mahato,
No,
has approached this
petitioner
court.
has no grievance against this.
Yes.
So they are not concerned.
No.
Very good.
Second.
Roman 2.
Let a copy of this order be sent to Director General of Police, Jharkhand, and the Deputy Commissioner Bokaro with a copy number of letter number such and such, dated such and such, addressed to the Principal Secretary, Government of Jharkhand, Ranchi, and the direction given by the Deputy Secretary to the Government Department of Forest and Environment, Jharkhand, Ranchi, while letter number such and such, dated such and such, so that appropriate action from their end may be taken, and they are directed to submit action report within the 3 months from the. This is not.
What
a
is the appropriate action?
Yes.
What is the appropriate action?
Appropriate action, my lord. First part may kindly be seen of Roman 2.
Yes.
Let a copy of this order be sent to the Director General of Police, Jharkhand, and the Deputy Commissioner Bokaro with a copy of letter number such and such, dated such and such, addressed to the Principal Secretary, Forest, Government of Jharkhand, Ranchi, and the direction given by the Deputy Secretary, not by the Honorable Lokayukta, to the Government Department of Jharkhand and Environment, Ranchi, by letter number such and such, so that appropriate action. The action was, there was direction for taking action, but in pursuant to the letter which was issued by the Director, Principal Secretary, Forest, Government of Jharkhand, Ranchi. So no fresh order has been passed by the
That's
Honorable.
So they are not directly aggrieved by this direction.
No, in my humble submission.
If any action has to be taken, then they will have their own
Yes, sir.
opportunity. They will have their own
sky is open,
opportunity.
madam. The sky is open. If anything will come, then they will approach the court.
All right. Then what happened?
Thereafter, my lord, now, my lord, from the pleadings, my lord,
Why Roman 3?
Roman 3 is the copy of this order may be sent to the secretary, MOH such and
ये
such,
किस लिए भेजा?
for future reference.
Why? Why?
ये प्रोसीडिंग इनके अगेंस्ट में चला रहे हैं अथॉरिटी के अगेंस्ट.
Why is it required at all?
It has not been discussed, so it will
No,
not
let
go
me
against
just-
it. It will not go affect the petitioner
Yes.
in
It
any
is-
way.
It is affecting the petitioner because now their clearance is pending before the government of India.
Malord,
Now there are certain observations made in this order against them, right? So what they want simply is that whatever observations have been made in this order may not be used per se against them, and if any such proceeding is initiated, this should not prejudice them in any manner. This is what they want, simple. इसके अलावा तो कुछ नहीं चाहिए. आपने भेजा है, इसका क्या
वो तो
purpose?
मांग ही नहीं रहे हैं हुजूर.
नहीं,
वो
नहीं.
तो मांग ही नहीं रहे हैं. उनका प्रेयर ही पर देखा है.
नहीं, उनका प्रेयर अभी जो वो अपना प्रेयर किए ना, बस उतना ही भर प्रेयर है.
नहीं, वो तो रीड से ना देखिएगा.
We can always mold the relief.
Now the
they have challenged
Supreme Court 2023.
हाँ.
Malord में will
I will take care of that. I know my jurisdiction. दो अब मेरे jurisdiction क्या?
नहीं, jurisdiction पे बोल ही नहीं रहे. So what the Supreme Court has said, Malord, that if the prayer is there for X, the court should not be allowed to give finding of prayer.
देखिए, जब आप सुप्रीम कोर्ट का जजमेंट साइट करिए ना, तो आप विद्वान हैं, हम विद्वान नहीं हैं. आपको जजमेंट साइट करना पड़ेगा.
वो मंगा देते हैं.
लाइए तुरंत, आज फाइनल हियरिंग पर है.
ठीक है, हम मंगा देते हैं.
मंगाइए. ठीक है, वो हम सोचेंगे. अच्छा, इसका मतलब ये हुआ कि आप उनके अगेंस्ट में कुछ भी ऑब्जर्वेशन करें?
नहीं, कुछ भी नहीं है. हम उस पे भी आ रहे हैं. उस पे भी आ रहे हैं.
आगे पढ़िए. Yes, so Roman 3 is basically to
Malord, in Roman 3, my submission would be there is nothing against the petitioner which will affect. It has to be seen by the authorities of Union of India. They will have to apply their mind, and the order will be passed in accordance with law. Now the fourth one, Malord.
Yes.
In fact, cognizance has not been taken against chairman board. Rather, he was asked to appear to assist the undersigned. This direction was given only because the present member secretary board has been found not cooperative, playing hide and seek. It is also essential to mention that the chairman board, Sri A.K. Pandey, has not completed even 1 year after taking charge, and it is evident from the documents available on record that member secretaries did not place appropriate facts before the chairman. Hence, I do not feel inclined to give any finding against him. So, my lord, this will also not affect the petitioner. Now, my lord, may kindly have a look. All the things has come during the proceeding, and on the basis of the report which has been placed before him. My lord, the page 111.
Yes, 111.
The present member secretary, Sanjay Kumar Suman, in his so-called, has made it clear that so-called notice while letter number 980 dated such and such and reminder dated such and such were issued against Messrs. Electro Steels Limited. It appears from the conduct of the present member secretary that he had started playing tactics and did not act upon diligently on the issue. I am making this observation against present member secretary because of the reason the divisional forest officer Bokaro Forest Division, Bokaro by its letter number such and such, dated such and reminder number such and such, dated such and such, has clearly brought it to the notice of the board that the company has encroached the forest land. So this is not the finding given by the Honorable Lokayukta, rather it has come during the proceeding of the case and on the basis of document available on the record.
That's right.
But instead of considering a aforesaid fact, the member secretary started interpreting the issue that board is not empowered to decide the title of the parties at the time of granting security. Now, my lord, since my lord has perhaps opens mind.
देखिए, हम तो लुका छिपी खेलने
नहीं, इसीलिए
आपसे सवाल पूछ रहे हैं, जवाब दीजिए, ऑर्डर लेके जाइए.
हाँ, तो जवाब वही कोशिश
जवाब ही खोज रहे हैं, अभी तक मिला नहीं है. जवाब खोज रहे हैं तो मिला नहीं. डायरेक्शंस आप बोले हैं, नथिंग इज अगेंस्ट हिम.
Yes.
Right?
Yes.
This is one. ये जो findings है clear cut that they are encroachers, right? They are violators of environmental laws, right? These are specific findings recorded against them. Either you say that they are not findings, I will record your submission that it is not findings.
My lord, it is my lord's prerogative. I have nothing to do, my lord.
Those,
My lord, I am only
first I
trying to
want to
assist.
know from you
Yes.
that whether the Honorable Lokayukta has recorded certain findings against the petitioner or not. You just tell me yes
My lord,
or no.
yes. To some
Records.
extent. To some extent.
So under such circumstances, was it not incumbent upon him whether these findings, whatever has been recorded by the Honorable Lokayukta with regard to his environmental clearance, etc., will have any bearing in any of the proceedings?
My lord, what has happened in this case? That my lord, the complainant has made a complaint before the Honorable Lokayukta against the against the officers of the Pollution Control Board, not against the electoral still. So, my lord, every report which was called for by the Honorable Lokayukta with regard to the conduct of the board and what steps, what measures has been taken by the board, that has to be seen by the Honorable Lokayukta. This was the, my lord, first my submission is that
in order to scrutinize the conduct of
yes,
the officer,
that was all
it
incidental.
was for the Honorable Lokayukta to refer to these materials,
yes, incidental.
And
yes,
after having recorded its finding, the directions were issued, right?
Yes.
But these findings, when it is pitted against the petitioner in any proceedings, should it prejudice the petitioner in any manner? Because if you say that these findings are recorded on the basis of materials on record, the authorities would say there is a conclusive finding and matter ends. फिर क्या होगा? कुछ नहीं होगा. Nothing.
वो उसको चैलेंज करेंगे, उसको कैसे नहीं होगा? वो चैलेंज करेंगे ऑन द बेसिस जो ये करेंगे, जिनका जो एग्रीड होंगे वो चैलेंज करेंगे. अगर इनको नहीं मिल रहा है, मान लीजिए सपोज
अगर मान लीजिए एनवायरमेंटल क्लियरेंस के लिए जाएं, हाँ, एनवायरमेंटल क्लियरेंस में बोले कि दिस इज द फाइंडिंग्स ऑफ द ऑनरेबल लोकायुक्त, therefore you are not entitled, right? Then that would be good.
अब क्या भविष्य में क्या होगा?
भविष्य में नहीं, यही हो रहा है.
नहीं तो इसके लिए तो ये रीट में
इसीलिए नहीं. Therefore any observations which have been made, any findings which have been recorded, that could be a finding so far as the person concerned is concerned, right? The violator of your public officer, right? But so far as they are concerned, it should not prejudice them, right? if अगर मान लीजिए कोई FIR इंस्टीट्यूट हो ही जाता है, तो FIR जब इंस्टीट्यूट होगा, they will have their own opportunities to defend themselves.
Yes, definitely.
जब ये environmental clearance का कोई issue आएगा, they will have their own opportunity to defend
themselves. ये तो इनके साथ आते ही रहता है.
इतना ही तो चाहते हैं, इसके अलावा थोड़ी कुछ नहीं.
ये तो हमेसा इनके साथ आता है और हमेशा ये फिर जाके उसको फेस करते हैं.
तो इसीलिए इसी वजह से
the finding, मतलब what I am submitting, the finding is not against the electricity directly or in any manner indirectly.
इनडायरेक्टली फाइंडिंग पढ़ी है ना आपको? फाइंडिंग नहीं लग रहा है?
3 आप बोल रही हैं, 3 में कोई फाइंडिंग नहीं है.
3 का नहीं बोल रहे हैं हम आपको, पूरा अभी कितना इन्होंने पढ़ाया. You see, but the fact remains that the fact remains that the company has encroached more than 200 acres of forest land, right? And then further finding, पढ़ के सुनाते हैं, आपने नहीं पढ़ा होगा, ठीक है? The entire episode moving around the encroachment of forest land by Messrs. Electrosteel, that is the root of the matter. In fact, the company, under garb of purchase of piece of land from the vendor, got a decree in title suit, has encroached more than 200 acres of land.
That has come on the basis of the report which has been placed by the Deputy Commissioner Bokaro.
That's right. Suppose any proceeding is instituted against the petitioner, then under such circumstances, he has got a right to defend himself without being prejudiced by any observation. This is what he wants, nothing more.
But prayer is not that.
वो हम prayer का हम
prayer is not that. Prayer is
prayer.
The order has never been passed against the electricity, the petitioner. Now what they have prayed, my lord, we kindly have a look.
We will see that.
My lord, हमको तो आगे करने दीजिए.
हम सुन रहे हैं
आप
prayer.
कंक्लूड कर
Repeat
दीजिएगा
मत
ऐसे, तब
करिए,
तो
हम
फिर हम
conclude नहीं कर रहे हैं.
आई विल बी आउट ऑफ द
I have registered your argument. You don't
नहीं,
need to
नहीं हो रहा
repeat
है
it.
हुजूर, नहीं हो रहा है। हमको तो
जब
ऐसा
तक
फील हो रहा है कि हम ऐसे ही बात कर रहे हैं।
रजिस्टर किए हैं लेकिन रिजेक्ट तो कर ही सकते हैं ना.
आप करिएगा, रिजेक्ट कर दीजिएगा, मेरा सबमिशन तो आने दीजिए।
सबमिशन आपका आ गया.
मेरा सबमिशन नहीं आया है।
क्या चीज नहीं आया?
अभी हम जो बहस कर रहे हैं उसको तो देखिए।
देख ही रहे हैं.
My lord,
कौन सा बहस
my lord,
करना?
my lord,
पॉइंट
मैं-
वाइज आप बहस करिए.
हाँ,
चलिए.
point वाइज
हाँ,
बात। My
point number one.
my first point is that the prayer which has been made by the petitioner.
Yes.
My lord, the first prayer, an appropriate read, order or
You
direction
don't need to
command.
read it. आप बताइए. प्रेयर बताइए.
My lord,
उसमें क्या
I
objection
may be
है?
allowed to argue, my lord, on my own.
भाई he is challenging the order of the honorable.
No, twofold prayer is there.
Yes.
First is to transmit record of the case number such and such, including dated such and such, passed by learned lokayukta, as despite application dated 11/6/2018, till date certified copy order has not been made available to the petitioner, and upon receipt of the records of the case, was the order dated 22/12/2017. Admittedly, the order has not been passed against the petitioner. Now, my lord,
Just a moment. 22/12/2017 is the order that we are reading,
Yes.
which is on record,
yes.
right? तो अब तो ट्रांसमिट का कोई बात ही नहीं है. दिस इज एन एडमिटेड डॉक्यूमेंट ऑन रिकॉर्ड.
नहीं, वही तो हम दिखाना चाह रहे हैं कि this prayer is contradictory to the pleading of the petitioner.
That's right. Contradictory.
Yes.
Okay. Prayer 1 is contradictory, so it is meaningless, right?
My lord, may kindly look to prayer page number 17, para number 24. If the certified copy has never been supplied to the petitioner, then from where this order has been quoted?
That's right. Okay. We have seen that. We have seen it. They have annexed it.
But
It is absolute.
it has
This
to be
prayer number
pointed
one.
out.
Prayer number 1 is rejected. और कुछ चाहिए आपको?
Now, prayer number 2.
चलिए. There is no requirement for prayer number 1. It has
No.
become infructuous.
My lord. Prayer number 2. An appropriate read, order or direction for quashing of order dated 22/12/2017 passed by learned lokayukta in case number such and such, wherein in sheer violation of principles of natural justice without affording any opportunity of hearing to the petitioner in the said adverse observation sweeping allegations have been recorded against the petitioner. My lord, the order dated 22/12/2017 has never been passed against the petitioner. So this prayer is also not tenable in the eyes of law because of the fact that no order has been passed. My lord, the order has been passed against the Mahendra Mahato. He has preferred a writ petition that is pending before this honorable court. No order has been passed. So any order which will given allowing the petitioner in this case will affect the case of the petitioner.
What is the red petition number?
My lord, that I will supply, my lord, in this case.
I will supply मतलब क्या?
नहीं,
After
वो
the
मेरे
order.
पास नंबर है उसका, लेकिन इसमें नहीं, इस फाइल में नहीं। महेंद्र तो चूंकि कॉपी सर्विस हुआ था।
देखिए आपका सबमिशन अभी लिखाते हैं, ठीक है?
ठीक है।
The learned counsel appearing on behalf of learned lokayukta has referred to the prayers made in the writ petition and has submitted that so far as prayer number 1 is concerned, the order impugned in this case dated 22/12/2017 has already been placed on record and therefore it is contradictory.
At para 24.
During the course of argument, it is not in dispute that the order dated 22/12/2017 passed by Honorable learned lokayukta is at annexure number 12 of the writ petition. Right? Okay? So far as prayer number 2 is concerned, the learned counsel has submitted that the said prayer is not maintainable in view of the fact that the petitioner is neither a party before the Honorable lokayukta nor any direction has been passed against the petitioner. That's all?
No. Next.
ये हो गया आपका, सुन लिया और बताइए फर्दर आर्गुमेंट.
हाँ.
पॉइंट नंबर 2 पढ़िए.
Point number 2, that what has come against the petitioner in the impugned order dated 22/12/2017. My lord, it was in the proceeding of the case in which the report was called for and on the basis of report, each and every report, the order has been passed. My lord, the 111 I have placed, my lord, page 111. Page 111 I have placed.
The Learned Counsel has further submitted that the findings of the Learned Lokayukt, which has been arrived at in the impugned order, is based on the reports which were filed before the Learned Lokayukt. And essentially, the conduct of the concerned officers has been scrutinized by the Learned Lokayukt.
And the entire order, it was incidental. It was incidental.
He has further submitted that the observations in connection with the petitioner were only incidental in order to arrive at a conclusion with regard to the conduct of the concerned officers.
Now, so far, my lord, expunging is there. Expunging of the some observation.
He is not praying for expunging. That is not his prayer.
Two prayers are there, my lord. I have
The Learned Counsel has also submitted that the concerned officer against whom the Learned Lokayukt has passed the impugned order has also filed a separate writ petition before this court, which is pending. And if the impugned
Mahendra.
order, Mahendra Mehto, if the impugned order is set aside, then the other writ petition will become infructuous. That's all. कुछ छूटा है आपका?
एक बार और refresh.
आप क्या आप फिर से
एक आध point हम बहस
नहीं
नहीं
आपको जो बहस करना है अभी बहस करिए. 4 राउंड थोड़ी होगा. आपको
नहीं,
जो
4
बहस-
राउंड अब
हाँ, आपसे पूछ के लिखा रहे हैं. आप बताइए आपको.
हाँ,
आप
नहीं,
बोलते
जो-
हैं आपका पॉइंट नहीं लिखा है. तो
ना
point लिखा
ऐसा
है.
आप कभी नहीं बोल सकते.
नहीं बोल
ना,
नहीं
हम
सकते.
केवल प्लेस करते हैं जो फैक्ट.
बोल ही सकते हैं.
नहीं बोल
आप-
सकते.
बोल-
ये तो हम कभी नहीं बोल सकते.
आपका एकदम पूरा जुरिस्डिक्शन है बोलने का. हम लोगों को नहीं है बोलने का जुरिस्डिक्शन.
हुजूर का तो सारा जुरिस्डिक्शन है.
ऐसा तो कोई बोल ही नहीं सकता है कि हम बिना सुन के किसी
ना
को
कभी
order
नहीं. और तो होता ही नहीं कभी ऐसा. वो हम लोग बोलते भी नहीं हुजूर के कोर्ट में.
और आपका केस में वो भी ऑर्डर किए हैं जो आप बहस भी नहीं किए.
जी.
किए है ना.
हाँ एकदम.
जो आप बहस भी नहीं किए.
जी.
तो
इसका
कैसे आप बोल सकते हैं?
एक्चुअली इसका रिपरकेशन इस केस का बहुत ऊपर तक होगा. इसीलिए थोड़ा मेहनत कर लेना पड़ रहा है क्योंकि इसका रिपरकेशन हम लोग समझ रहे हैं कि क्या होगा. हुजूर तो जो ऑर्डर करना होगा करेंगे हम लोग आर्गुमेंट के बेसिस.
ऐसा है ना कि लॉ के बाहर हम लोग को दिखता नहीं
नहीं,
है और
एकदम
रिकॉर्ड
नहीं.
के बाहर हम सुनते
दिखना भी
नहीं.
नहीं चाहिए हुजूर.
ठीक है. और रिकॉर्ड के बाहर हम सुनते भी नहीं किसी का बात. इसीलिए आप हमको और जो बोलना है बोलिए.
ठीक.
हो गया. यस. प्राइवेट रिस्पोंडेंट.
But first, they are
You
saying
are
that
Ajay
Ajay
Dubey.
Kumar, Ajay Dubey.
One liberty, my lord. I will bring the judgment. in
प्लेस
which-
करना पड़ेगा.
अभी
ऐसे
ला दे रही हूँ.
लेके प्लेस करिए उसको. यस.
Now, Lord, they are only coming that we are aggrieved. Certain finding has been given in the order by the Honorable Lokayukt. We are aggrieved by that. Now, whether that is a direction or whether it has got evidentiary value, whether it is an order or judgment, that is to be decided.
That's it.
It is not even neither an order, it is neither a judgment. It is a simple report, and after that report, my lord, the cognizance can be taken and initiation can be done. So they cannot say that finding has been given, it has got, my lord, permanent value. It has got no value
Yes.
in the eye of the law. If Lord will, I will
Just a
deal on the
moment,
Lord
just a
Lokayukta Act,
moment,
my
just
lord.
a moment. The findings of the Learned Lokayukt, according to you, is only a report.
Report, that is the law, my lord. And they are not aggrieved by this order. They are aggrieved by the reports of the Ministry of Forest and Climate, not by this report. So they are intermingling the issues. Now, till that I have verified the order of the Supreme Court. The Supreme Court has also said, my lord, yes, clearance may be granted in accordance with law, not by this Lokayukta report.
That's
So within 3 months, the NOC can be granted in accordance with law, and they are not able to satisfy the, my lord, ministry.
So that is the problem, not this report. Now, Milord, say they are saying that we are not
So
party.
do you want to say that this report by itself will have no bearing on
No
any
bearing,
litigation?
yes. Milord, this is the order passed in their writ application. Milord, this industry itself is running right from beginning by the stay granted by the High Court or by the Supreme Court, not by the law. Milord,
So petitioner would be otherwise governed by law.
Not say governed by law, but not they are not taking benefit from the interim orders. Your Lordship has vacated the interim order. They have challenged that this is the final order.
So you were party in that proceedings?
I applied, and because I was not added as a party, I was heard there. I was not added as a party as because I was not implemented party in that proceeding. Although right of hearing was given here also, but there also the Supreme Court says since we are not the party, we will not allow you to add as a party. Milord. So we were heard. And the last paragraph I can say a lot of things has been done. There is no encroachment. They have submitted. All laws have been cited. And final paragraph is paragraph 87. Your Lordship has heard and hearing this matter. The appeal is allowed. The appeal are allowed. The impugned order is set aside. Respondent number 1 shall take a decision on the application of the appellant for revised environmental clearance in accordance with the law. So what they are hampering, Milord, there also they have not said to the Supreme Court that this lokayukta order is having some difficulty. They have simply
So
said.
according to you, they are not at all agreed by
No,
this because this is not being used against them.
No, Milord, kindly see, Milord, why
I'll just note it down
Yes,
that
yes.
it is not being used against them. लिखिए तो the learned counsel for the private respondent who was the complainant before the learned lokayukta has submitted that the impugned judgment of the learned lokayukta is nothing but a report, and the same has no bearing
Yes.
on any proceedings by or against the petitioner.
Because when Milord DGP.
The petitioner is bound to be dealt with by the authorities in accordance with law and not by the impugned order.
Milord, kindly see, Milord, what I am saying.
He
Milord,
has
what-
further submitted that the impugned order passed by the learned lokayukta has never been used against the petitioner to the best of his knowledge.
Milord, I kindly see, Milord, annexure 9, Milord, of the writ application. The typed copy have also been provided by the petitioner, annexure 9. Milord, when the
Yes, yes.
Milord, when the notices were issued to the Ministry of Environment and Climate Department, they Milord challenged this. What they challenged, Milord, two things. The notice issued by the Milord lokayukta and the notice issued by the Ministry of Forestry and Environmental Clearance. And there they failed, Milord. And when the report was submitted against them, and what was the finding which was recorded in the which they are saying in the report that everything is against me, recorded ex parte by the Honorable Lokayukta, it is absolutely incorrect because direction was given, go and cooperate in the investigation.
No, cooperating in the investigation and being a party to the proceedings.
Milord, Milord, kindly see, Milord,
They are
kindly
bound to
see.
cooperate. What is
Yes,
the
yes,
big deal about
they are
it?
bound to
They
cooperate.
are bound to cooperate.
Yes.
कोई inspection करने आएगा तो they are bound to cooperate.
तो हुजूर,
कोई
उसमें-
report बनाने आएगा they are bound to cooperate.
इस रिपोर्ट में सारा कुछ अगेंस्ट है उनके
होगा।
उसी रिपोर्ट को लोकायुक्त ने कोट
I
किया
just
है।
want to know one thing. आप तक criminal angle से सोचिए इसको, ठीक है? Criminal
जी
procedure,
सोच रहे हैं।
right? An accused is supposed to cooperate with the proceedings. And he cooperates with the proceedings. All the investigations are done and findings are against him by the police report, everything submitted, charge sheet submitted, right? Will he become a party in the proceedings before the
No.
court? Before the
Milord,
court,
in this, Milord,
before the court,
Before
will he
the
become
court,
a
he
party?
will,
Yes.
he will.
Therefore, when
Before the court, he
when the learned lokayukta is taking into consideration the report, was it not the duty of the office of the learned lokayukta to issue notice to
My lord, I will come on this. That is the discretionary power, my lord. He may not. And
may
there
or
is a
may-
judgment. Yes, it is a discretionary power because, my lord, kindly see, my lord, first I am reading this annexure 9, page 72, my lord. So, because why I am saying it is a report, and the report is to be acted upon by the state authorities, not by the, my lord, lokayukta. Lokayukta has not got that power, my lord. He can only recommend, this is my report, you may act upon, may do not act upon.
So he does not have any power to call for a
No.
compliance report?
No.
So why this
So,
compliance report?
compliance report, my lord,
There is a
he
there is
can
a
only
direction
that.
to
Yes,
file
my
a
lord, kindly
compliance
see
report.
that word has, my lord, miscategory missing. He has to only say, yes, this is my report, act upon.
So why
So
subsequent
that's not
orders
the-
have been passed by the office of?
My lord, I will
Because
place the,
there are subsequent orders also.
yes, I will place, my lord, the provision of the Lokayukta Act, my lord. First, my lord, this annexure 9, my lord, kindly see what they have challenged. Challenge the proceeding of the lokayukta as well as the proceeding that they are not issued the notice for cooperating in the, we will not. But the honorable court has dismissed. This has become final. They have not challenged. Then this report submitted against them has
Where is the order of dismissal?
annexure 9, my lord,
पढ़िए
page 72. My lord,
पढ़िए
order.
72
Yes, yes, my lord.
पढ़िए
Order 3rd August 2017 issue notice upon respond number 4 after hearing the argument advanced by the learned counsel for the petitioner and Mr. Rajiv Sinha, the learned SGGI, this court directs that the petitioner shall cooperate in the inspection done to be done by the regional authority of Ministry of so and so in terms of the letter dated 26/7/2017 annexure 11. Learned SGI shall file the counter affidavit along with the report and order dated so and so. Still, the application is pending.
Yes, it is listed. Second case.
Second case is listed. So, if they have cooperated and inspection has been done, then Lord, and that inspection report they have not challenged in anywhere, in any case. They are simply coming that we are running an industry, having an employment, we are giving the employment, so we have to allow to be run. That is their case. And why if they are saying that no, we have not encroached any forest land, so why they are so assumptions that no, if we are not acquired a single acre of forest land or government land, so why they are afraid? Lord, this is my second submission. Now, my lord.
देखिए learned counsel for the private respondent has also referred to order dated 3rd of August 2017 passed in WPC number 4430 of 2017 within bracket annexure 9 to submit that there was a direction issued to the petitioner to cooperate in the inspection which was to be done by the regional team of MOFFCC in terms of letter dated 26/7/2017. The said repetition is the connected repetition with the present case.
What's the second my counter affidavit, madam? I have filed that on 26/9/2018. The first point which I have taken, that being the full knowledge of the proceeding, they did not intentionally participated. They have not filed any application before the lokayukta. They are alleging that yes, lokayukta has not added party, but they have not taken any step. Second, my lord, annexure 4, what I have submitted the power and jurisdiction of the honorable the lokayukta. So, if your lordship will say,
Just a moment. The learned counsel has referred to the counter affidavit dated 26/9/2018 passed by the private respondent and has submitted that in spite of having full knowledge that the proceeding was pending before the learned lokayukta, the petitioner neither filed any intervention nor took any steps to participate in the said proceedings, and therefore the impugned order cannot be said to have been passed in violation of principles of natural justice. यही है
हाँ, yes.
और बोलिए.
Now, look how it is in report, because the much water has flown there, because it is page 35 of this counter affidavit. Section 12. Before that, section 11 is also very relevant, because this, when evidence has been collected, that is another thing. That is the prerogative discretion of the lokayukta. And after doing this, what can he do? Is 12 below. If after investigation of any action which the complainant informed, 4. After forwarding this, the competent authority. So why they are aggrieved? Because 4 and 5. Who will take? He is only a recommending authority. Starts the prosecution start after the
You
case will be
read one
registered.
also.
Yes, my lord. If after investigation of any action in respect of which the complainant involving a grievance could be made, the local is satisfied that such action has resulted in injustice or undue hardship to the complainant or any person, the local shall, by a report in writing, recommend to the public servant and competent authority concerned that such injustice or undue hardship shall be remedied or redressed in such manner and such time may specified in the report. Always it is a report, Lord, word itself is a report. So, where is to be sent? The competent authority to whom the report is sent upon section so shall within 1 month of the expiry of the term specified in the report intimate or cause to be intimated to the lokayukta the action taken for compliance within the report. If after investigation of any action in respect of the which complaint involving allegation could have been made, the lokayukta satisfies such allegation can be substantiated without wholly or partly, he shall by a report in writing communicate his finding or recommendations along with the relevant document materials other evidence of the competent authority. The competent authority shall examine the report, forward it to its subsections and intimate within 3 months. What you lordship are asking, why 3 months, 1 month? 3 months of the date of receipt of the report, the lokayukta the action taken or proposed to be taken on the basis of report. So it is on the government whether they are acting, not acting, which the Department Prevention of Corruption Act. The lokayukta satisfied with the action taken and proposed to be taken on the case. After information to the complainant, the public servant and the competent authority concerned, but there is no, if he is not satisfied, if they consider that the case so deserves, we may make a special report upon the case to the governor and also information to the complainant concerned, where the report forwarded by the lokayukta, any recommendation imposing the penalty for removing the office for public servant falling within sub clause so and so has been paid in shall be law for the government without any further inquiry to take, this has not been invoked, take action on the basis of said recommendation for the removal of such public servant from his office, making his ineligible for being elected of any office assigned by the government in the office, not with attending anything contained in any law for the time being. The lokayukta, there are now what is the difference? In other states, the lokayukta has been given.
The Learned Council has referred to section 12 of the Jharkhand Lokayukta Act 2001 to submit that the impugned order is termed as a report under the said provision, and the directions in terms of section 12 thereof is given with regard to consequential action on the basis of report.
Lord, what has happened? So, Lord, in other states, in some other states, Lord, the lokayut has got direct power to take cognizance, and there are lokayut police in Lord, UP, Bihar, Jharkhand. No such power has been given to the lokayut. Therefore, the entire power of only the lokayut in the state of Jharkhand has got a preparation of report
That's
and nothing more. And the government concerned departments, like in this case, Lord, Prevention of Corruption Act, will register after this the regular procedure, Lord, PE, Lord, preliminary inquiry, then Lord, regular. Why they are afraid of these things? These are report simple.
They're not government servants.
No, no.
Why should they be afraid of you?
No, they are saying this. We are aggrieved by this order because finding has been given.
That's
No
true.
finding has been given is them. Only report has been quoted, and that report was within their knowledge, and they have not challenged that report. And if they have not challenged that report, now they cannot say that why the lokayukt has quoted that order in his finding. It's not their now they have not challenged that order. I will come also on that, Lord. What is against them and what has been quoted by the lokayukt. Now, my Lord, they have said that we have not been heard. So, my Lord, this another annexure B, page 43, is the parameteria provision of Uttar Pradesh Lokayukta Act, my Lord, 1975. Here, my Lord, in Jharkhand, Bihar, 1976. So, why I am referring this, my Lord? The parameteria 51.
No, you have to refer to our act only.
No, Lord, I am relying on this, Lord, because this has been considered in Lecture C, page 62, in the Supreme Court judgment, Lord, 2015, volume 8, SCC 117. So this
Saying what? That this provision has to be read into other acts.
No, that is not that.
Okay.
Here, my Lord, the issue of parameteria provision, section 11 and 12, which is in our Jharkhand, same provision, my Lord. It has held, my Lord, kindly see the paragraph, last paragraph, my Lord, take time, paragraph 20. There was also the same provision. He was also a cabinet minister. He was not heard by the lokayut, report was forwarded, my Lord. Then the, my Lord, Supreme Court say it is the discretion as per the act. My Lord, what I said, section 12 of the Lokayukta Act, Jharkhand, which is only 76, it is 75. Parameteria Act, if Lordship will verify.
Yes.
Why it may I read more para 20 of that judgment, page 72. Lord.
Yes. Read it.
Lordship, while it is correct that the report of the Lokayukta was submitted without affording any opportunity of personal hearing to the appellant, and the request for time of submission of document made by the appellant on so and so was refused by the lokayuk, the said fact cannot constitute a good and sufficient basis for this court to find fault with the conduct of the proceeding of the lokayuk UP, in which the provision of section 10(3) of the act is already noticed, leaves to the lokayuk the discretion to adopt such procedure as may consider appropriate. In the given fact of the case, no prejudice also has been caused to the appellant who has taken part in the proceeding at every stage. The refusal to grant further time to the appellant is so and so, so and so. Now, Lord, the parameteria provision, the whatever discretion, it's on the lokayuk. 10, here also same provision 10, here also, Lord, report 12, and whatever provision. It is the discretion.
Which provision? Which is para
10, my Lord.
Para 10, section 10 of
same, my Lord, come to the Jharkhand Act. 10, my
Jharkhand
Lord.
Act में कौन सा provision?
10 ही आएगा उसमें. दोनों में एक ही आता है.
Procedure in respect of investigation.
Yes. दोनों में सेम ही आता है. वो यूपी वाले एक्ट में भी सेम आता है, इसमें भी यही आता है.
The Learned Counsel has referred to the judgment passed by the Honorable Supreme Court, reported in bracket 2015 bracket close 8 SCC 117, and has submitted that the procedure to be followed by learned lokayukt is left to his
Yes,
discretion.
sir. Page 32, Lord.
Is left to his discretion, and in a case where the report of lokayukta was submitted without affording any opportunity of personal hearing to the appellants of the said case, the plea was rejected by para 20, which is quoted as under. He submits that the
Page 32,
provision
Lord.
of section 10
3.
of 10.3
Yes.
of Uttar Pradesh
No, this is Jharkhand.
of Uttar Pradesh Lokayukta and Up Lokayukta Act 1975, which was subject matter of consideration before the Honorable Supreme Court, is parameteria to section 10 within bracket 3 of the Jharkhand Lokayukta.
Lord, this was Lord of the 1976-2001 adopted in the state of Jharkhand. That's all. Now, Lord, the thing which they are saying again and again that Lokayukta has quoted this, Lokayukta has quoted, and that is not correct. Kindly see, Lord, Annexure D, page 8. What is against them? This is against them, and if they will not cope up with this, I have got no case. This is the report, and prior to that report, based on the report of the Ministry
Annexure?
that is reply to the rejoinder filed on behalf of the petitioner. This was filed on 16/7/2019.
Yes, what is it?
Lord, this the what has been narrated in the order of the Lokayukta.
Where is it?
Lordship.
Annexure D.
Annexure D, page 8. Lord. Kindly see, Lord, page 21. And this they have not been challenged. And if this they are not challenging, how they are challenging the report which is based on these things?
Page 21, they are not challenging the report.
They are saying
Page
this
21.
because of these.
Which page are you referring? You just
Lord,
state
page
the paper.
21
Page 21 is in the
Lord.
midst of the some proceeding.
Not sir?
Page 21 is page 9. Page
No,
21.
Lord, starts Lord, page D, page 8, Lord.
Page-
And a rejoinder which was filed on,
Page D, page 8. What is it?
Lord, this is the report.
This is not under challenge.
Revocation. This was under challenge up to the Supreme Court.
This is not under challenge in this proceeding.
This is not under
We are
challenge.
not concerned with that.
No, Lord, if they will not challenge,
This is not under challenge in this proceeding.
Lord, what these reports has been considered and it has got an evidentiary value, and if they will not deny.
Is this report,
Lord.
has this report dated 20th of September 2018
Lord, sir.
considered in the impugned order passed by the Honorable Lokayukta?
Lord,
No.
kindly see, Lord, yes. Lord,
It has been passed in 2017. This is 2018.
Lord, kindly see, Lord, I am coming, Lord, page 21. Based on the inspection, these order and revocation has been passed. It is not in isolation.
That is a separate thing.
How separate, my Lord? They are challenging the incidental issues. They are saying that incidental finding has been given. The Honorable Lokayukta has said that yes, because I am passing a report against the officer of the Pollution Control Board, as the issue is incidental based on the report, and if they are not challenging this report at anywhere,
Which report they are not challenging?
So what
Give
can
me
I
the
do?
date of the report which they are not challenging.
Lord,
Give me the date of
Yes,
the report which they are not challenging, and whether that report is a subject matter of the present case.
Lord, sir, earlier.
I want to know. You said that they have not challenged the report.
Lord,
Which is
may
that
I-
report they have
Lord,
not
kindly
challenged?
see, my Lord, the inspection report
Dated
finding has been given at paragraph page 21. It starts from para 9, and it was done in presence of them, and after that report the revocation order was passed and which was challenged by them, and still it is by the Supreme Court in accordance with law, and still this violation has not been, and they will never met, my Lord.
Is
Because-
this the subject matter of the present case?
This is. Why, Lord, kindly see what they have submitted and what they were cited. We have not encroached any.
They are not
And
saying
land-
that. That is not their
That
case.
they have said.
No,
They
you are
have
not
said
holding
that
property.
the land which was encroached, we have not encroached a single inch. The finding has been given erroneously without hearing
They
me.
are not saying anything.
This has
They
said,
are
they have
not
said
saying
this.
anything of that side. That
But the submission was this.
no.
Then it is not my case. I am, if they are saying that we have, if they are say just opposite what I am submitting, then
Their
what can-
only argument is that whatever observations or directions or findings, if any, which are there in the impugned order, should not prejudice them in any proceedings in which they are a party, either as a plaintiff or a defendant. That is their only thing. अगर
Milord-
उनके ऊपर कुछ proceeding होता है, then they will have their own say. Simple.
the Supreme Court ordered me whether they have argued in the Supreme Court. I have placed to the whether in any submission they have said this. Up to the Supreme Court, they have not said a single word that
Need not.
Then why?
Need not, because that was a proceeding arising out of environmental clearances.
Milord, this is also Milord, because they will have to not comply the order, and therefore they are afraid, and they are saying that yes, we have not encroached any forest land, and therefore clearance may be given. So incidentally,
So
same thing.
do you think that I will give a finding over here that they have not encroached any
But
forest
if
land?
that will be recorded, that the report of the lokayukta will not be taken into account for any practical purpose, then it will. They will favor them, and then now they will say, हम तो इतना ही चाहते हैं कि भाई वो in accordance with law कर ले. If they want, मतलब ये order भी हो गया हुए दिसंबर 9 2021 का है, आज तक तो इनको नहीं मिला फॉरेस्ट, कह रहे हैं जमीन नहीं मिली, पेड़ नहीं लगा पा रहे हैं. So this will happen when there is a flaw in the law, and when somebody has committed illegality, there should be some of it, because 200 and the total area is 500 acres, approx or hectares, I am not remembering in factually. So ultimately, this industry, I admit, employments are being provided. So illegally, if something has been installed, so whether it can be regularized, by whatever mean it cannot be
Good
regularized.
results will not justify illegal acts.
No,
There is
what
no
I
doubt
say,
on that.
what I say, the report of the lokayukta was based on the concurrent report, which they have also participated in that report. And so, if they are now saying that yes, we have not said, so they have to say that yes, that report was wrong, because that report is based by the lokayukta on a conclusive finding which they have participated
You have
in.
understood.
Yes, Milord.
अभी कुछ और बाकी है तो बताइए.
देख लेते हैं जो कुछ मार्क लगाए थे. फिर सेकंड वही पोल्यूशन कंट्रोल का है ऑर्डर, अभी तक सस्टेन कर रहा है, ये कहीं से स्टे खत्म नहीं हुआ है. दोनों का दोनों ऑर्डर सुप्रीम कोर्ट तक से भी खत्म नहीं हुआ है, इट स्टिल स्टैंड कर रहा है.
The learned counsel for the private respondent has submitted that till date the petitioner has not been able to obtain an environmental clearance, and the matter is pending before appropriate authority, and they are running their industry. However, it is not in dispute that an order was passed by the Honorable Supreme Court, reported in bracket 2023, within bracket then 6 SCC 615, in the case of the present petitioner, wherein a direction was issued for taking appropriate decision on the basis of revised environmental clearance in accordance with law within 3 months, and pending such decision, the operation of the steel plant was directed not to be interfered with. That's all.
No.
In सबका
What is the citation? 2024 to SCC 56.
sorry 2024
24. 2 SCC 570.
2 SCC 570.
70. Malad the I am
Prayer
placing
number,
page number
para
13,
number,
Malad, 13,
para.
page 13 Malad 24. केवल एक लाइन प्लेस करेंगे इट मतलब जहाँ बोल्ड वाला है ना उससे 3 लाइन ऊपर इट इज a right law that a party is not entitled to seek relief which he has not paid for.
This was a dispute arising out of consumer
Consumer
forum.
forum, but Malad, the law has been it has been held by the Supreme Court that this is a right law. And that's it.
इनका सबमिशन लिखे थे ना ऑनरेबल लोकायुक्त वाला उसी में ऐड करिए. The learned counsel has relied upon a judgment passed by the Honorable Supreme Court in Civil Appeal number 9106 of 2012, Messrs. Rajasthan Art Emporium versus Kuwait Airways and another, reported in bracket 2024 bracket close 2 SCC 570 and has referred to paragraph 24 of the state judgment to submit that the Honorable Supreme Court has observed that it is a right law that a party is not entitled to seek relief which he has not prayed for. Petitioner का submission हम नहीं लेंगे. सबका लिख लीजिए.
हम लोग क्या लिखाएंगे वही
आप लोग का इसलिए लिखा है क्योंकि आप लोग को ज़्यादा ग्रीवांस है.
नहीं, हम
The
लोग
learned
को
counsel.
नहीं गलत. हम लोग हमारा सिर्फ इतना ग्रीवांस है कि इन्वायरमेंट को रहने दो. ये इंडस्ट्री के नाम पर अभी जब गर्मी आती है तो वी ऑल टॉक अबाउट द ट्रीज एंड ऑल.
आप कितना
and
पेड़
old days
लगाए?
of Ranchi, my lord.
How
Old
many
days of
trees
हम
have
कम
you
से कम
planted?
1500 पेड़ लगा चुके हैं. अभी फिर 400 मंगाए.
old days of Ranchi हम लोग
इस
जानते
बार
हैं.
फिर अभी लगाएंगे तो 2000 हो जाएगा.
This is the problem. Manoj. We have to talk about sustainable development and not of just. I completely agree with what they are saying.
गाड़ी में
but-
बैठना छोड़ दिए हैं क्या?
हाँ, गाड़ी
नहीं,
में
वो तो
बैठ- नहीं, घर पर भी
या
छोड़ना
बिजली
पड़ेगा.
जलाना छोड़ दिए?
देखिए ऐसे कहने से तो नहीं चलेगा.
तो
but जितना
बैलेंस है ना?
संभव है ना.
सोसाइटी में एक बैलेंस चलता है.
नहीं बैलेंस चलता है.
देखिए
ऐसा
एक चीज बता रहे हैं मिस्टर. एक हम ऑर्डर पास किए, ऑनरेबल सुप्रीम कोर्ट के पास गया, सुप्रीम कोर्ट ने एक ऑर्डर पास किया. ठीक है, तो हम तो उसी अनुसार चलेंगे ना.
नहीं।
हम उसमें नहीं जा सकते हैं. हमारे पास जो रिकॉर्ड है और जो इम्प्यून्ड ऑर्डर है हम उसके बियॉन्ड क्या सोचेंगे.
हम
यहाँ
वही कह
पर
रहे हैं,
हम लोग
जो सुप्रीम
एनवायरमेंट
कोर्ट ने कहा है हम तो उसी पर कह रहे हैं कि इन अकॉर्डेंस विद लॉ पर आ जाए. दैट्स ऑल.
That's
But that
right.
again is
हमको
not
उससे
the
ज्यादा
Just
कुछ
a
नहीं
moment. The
चाहिए.
learned counsel for the petitioner has submitted that the petitioner was never issued any notice in the proceedings before the learned lokayukt, and accordingly no opportunity of hearing was ever given to the petitioner. He has submitted that he has no grievance with regard to any findings which has been recorded in the impugned order qua the erring officials. The petitioner is only aggrieved by findings and observations made in the impugned order which have been made at the back of the petitioner. The learned counsel submits that there are many proceedings pending in which the petitioner is participating as a plaintiff slash petitioner or as a defendant slash respondent. He would be satisfied if an appropriate observation is made by this court that the findings or observations in the impugned order may not prejudice the petitioners by placing his case before the appropriate authorities slash courts slash tribunals in the pending proceedings. That is enough?
That is enough, and my learned friend's answer is molding of relief. My lords, order 707 principles will apply.
Yes.
The two I have not
In
prayed for.
response, the learned, ये तो उनका petitioner का argument है ना. He has also referred to the entire impugned order and has highlighted the various findings, observations made by the Honorable Lokayukt. In response, the counsel for the petitioner has submitted that the petitioner has challenged the order passed by the Honorable Lokayukt on grounds of violation of principles of natural justice, and if the arguments of the petitioner is accepted, the same would amount to molding the relief within the parameters of the relief as prayed for in this writ petition.
The High Court under 226 can do so, but this is Dwarkanath versus ITO, AIR 66, Supreme Court 81, page 85, para 4.
He has relied upon judgment passed by the Honorable Supreme Court reported in AIR
1966,
1966
SC,
SC
81,
81
para 4 at page 85.
para 4
At page 85.
at page 85 by which has been passed in the context of
Molding.
Article 226 of the Constitution of India, and with regard to the judgment which has been relied upon by the private respondent, he submits that the said proceeding was not arising out of any writ jurisdiction
by the
by the learned or counsel appearing on behalf of the learned lokayukta.
I
The
could
said
also-
proceeding was not arising out of a writ proceeding.
I could also have taken objection of my learned friend defending the order because he has been only added as a party for sake of completeness. A tribunal or a body can't defend its order. That is what. He can't appear and defend an order of the lokayukta that my order is correct. And that is why you actually recollect there's a judgment of the Supreme Court says don't make them party.
That's
We had to make them a party because the certified copy was not given.
That's
So my learned friend has actually no locus to contest the case and say that my
the learned counsel has also submitted that technically the office of learned lokayuk has no lists in the matter,
yes.
and they are here only to, they were made party only for the purposes of production of record and no more.
Correct.
That's it.
That's it.
सब लिख लिए ना?
The judgment relied by my learned friend notes that Supreme Court judgment that Lokayukta section 10(3). In that case, the factual difference was that the respondent appellant was a public servant, and he had participated.
I was relied only for the purpose
Yes,
of
yes, yes.
discretion.
Just
That's a
the learned
They are the
counsel.
clarification
Just
that
a
is another
moment.
thing.
I noticed it. I forgot
yes.
to record it.
yes.
The learned counsel, while referring to the judgment reported in bracket 2015 8 SCC 117, which has been relied upon by the private respondent, has submitted that the case was, in the said case, the concerned appellant
Yes, ma'am.
was a public servant who was already participating in the proceedings,
Proceeding.
and he was aggrieved by
Personally.
by denial of opportunity
During
of
investigation.
personal hearing
During investigation.
during investigation.
Yes.
And therefore the said judgment has no bearing in this case. हो गया? दूसरा केस में क्या है?
दूसरा case
Consequential है?
वो orders were
दोनों में एक ही है उसमें nothing.
नहीं
नहीं
ये एक
दूसरा केस में क्या है?
clarify.
ये इलेक्ट्रोस्टील का कहानी को दो केस का तो
कंक्लूड हो जाएगा.
बताइए इसमें
During the
क्या है?
proceedings before the Learned Lokayukta, two notices were issued to me.
Hmm.
One is at page 59 by the Deputy Commissioner.
Yes.
अभी एक पढ़ देते हैं. विषय में देखिए माननीय लोकायुक्त झारखंड रांची द्वारा 9/5/17 को पारित
This
आदेश
is
के
this is the
during the pendency of the
that's
proceedings.
right. You were directed to cooperate.
Cooperate.
Then nothing remains.
Nothing remains. These are again is the 26/7.
And you have participated, and there is no further grievance.
Final order has been passed.
Final order has
No,
been passed.
final order is under challenge.
Yes. With respect to WPC number 3238 of 2018, the learned counsel for the parties have jointly submitted that the said proceedings was, that said petition was filed challenging certain notices issued to the petitioner by the Deputy Commissioner Bokaro
And
pursuant to orders passed by the learned Lokayuk. Now the
As also Annexure 11, which was
And-
issued by the Government of India and OEF.
अलग से Ministry of Government Environment and Forest भी किया था.
okay, and also notice issued by the Ministry of Environment, Forest and Climate Change. The Learned Counsel submits that the pursuant to interim order passed by this court, the petitioner has cooperated in the inquiry, and the inquiry report was submitted before the learned lokayukta, and an order was, and final order has already been passed, but of course the petitioner was never a party before the learned lokayukta.
Correct.
That's it.
This has become infructuous.
So this writ petition has practically become
infructuous. Yes.
हम jointly लिखे हैं सबके
हाँ,
साथ
जी,
इसलिए।
Infructuous. Yes.
रुक जाइए, हाँ बोलिए,
सेकंड केस में लोग यूनियन ऑफ इंडिया
आपको क्या बोलना है इसमें?
फ्रैक्चर्स हो गया मेरे
आप भी बोल ही रहे हैं ना, इन्फ्रक्चस हो गया।
सेकंड
Jointly
सेकंड केस में वो जॉइंटली बोल रहे हैं कि इन्फ्रक्चस हो गया। नोट कर लीजिए मिस्टर रवि प्रकाश,
आपको मतलब मोस्ट इम्पोर्टेंट की ज्वाइंटली बोल रहे हैं
वो रहे कि इन्फ्रक्चस हो गया।
इनका क्लियरेंस तो आना चाहिए।
Appearance.
The learned councils have jointly submitted that in the matter of environmental clearance, much water has flown.
Manoj, in reply, one thing here, Mr. Sinha has lastly submitted that the council for the lokayukta has no jurisdiction, no lease to argue the case, to assist the court. Manoj, in reply, Manoj.
No
I'm-
list, आपका कोई पर्सनल चीज नहीं।
No, personally, my lord, I have been appointed by the office of the lokayukta, not by the lokayukta, the authority order. I am for returning council of the office of the lokayukta, and my returnanship has been issued by the secretary of the lokayukta.
आप इतना
No, my lord, I am seriously objecting all these things.
अरे उनके ऊपर थोड़ी कह रहे हैं, हम कह रहे हैं ऑफिस ऑफ द लोकायुक्त।
Office
No,
of
no, I
the
am saying
lokayukta
I
has
am
nothing personal in this
No,
case.
no, nothing personal, but
That's all. फिर क्यों परेशान?
No, I think he's misunderstood, saying that he has. I am not doubting his secret worker. Your competence to appear.
अच्छा the learned counsel for the petitioner has relied upon the judgment passed by the Honorable Delhi High Court, reported in 2003 within bracket 69 bracket close DRJ 229 1 within bracket India Limited and others versus the lokayukta and others, and has submitted that and has referred to paragraph 16 thereof. जजमेंट किस दिन रखेंगे? जजमेंट का डेट दीजिए इसका।
ultimately आज conclude हो गया।
सुनने से हो ही जाता है और करना क्या? देखिए हम लोग का माय थॉट इज कि सुन के ऑर्डर करने से ज़्यादा अच्छा है। किसी का पॉइंट छूट, देखिए इट इज़ वन थिंग टू से दैट द जज हैज दिस point was argued, judge has decided in one way or the other. But when it comes to an aspersion that judge has neither recorded nor decided, तो बहुत सीरियस हो जाता है। कम से कम मेरे लिए तो बहुत मुश्किल है
ना, हुजूर तो
ऐसे एलिगेशन को झेलना।
पार्टी जब तक नहीं कंप्लीट होता है तब तक कंप्लीट भी नहीं करती है।
हम लोग कोई हड़बड़ी थोड़ी है,
सुन के हो रहा है, हर केस ही हो रहा है, तो एक केस के
हमको कोई जीवन में कोई हड़बड़ी
और हम
नहीं।
लोग को कोई ग्रीवांस भी नहीं है।
And I always say that pendency in the High Court or Supreme Court or wherever, अगर 4 घंटा का ऑपरेशन 4 घंटा में होगा ना, उसको 1 घंटा में नहीं किया जा
नहीं
सकता।
किया।
सुन लिए, ऑर्डर कर लिए, उसके बाद इसमें से कुछ एरर होगा तो आप लोग खोज के निकालिएगा।
नहीं एरर फिजूल कर देने के बाद एरर
हम लोग नहीं निकालते हैं जुर्म, वो तो फिर इधर
नहीं, आप लोग का काम है, इसमें क्या दिक्कत है? हमको कोई इसमें ग्रीवांस तो नहीं है। आई एम हैप्पी अबाउट इट।
इतना मोटा-मोटा फाइल
30 आठ
फाइल इतना मोटा-मोटा हो जा रहा है मुझे।
38
अप्लाई
30 अगस्त।
मैडम इसको करके हमसे लिखवा लीजिएगा, मेरा माइंड में भी फ्रेम है क्या करना है, डिले मत करिए, ठीक है?
हुजूर का ब्रीफ भी बहुत बल्कि हो गया। मतलब 38 अगस्त।
हाँ 30 अगस्त। ये भी उसी का पार्ट है। चलो नेक्स्ट केस पर।
I'm ready for final disposal. Item 1 WPL 6902 of 2017.
Yes, what is it, madam?
Madam, matter is a very small. The detailed order was already written by my lord on the previous occasion, my lord, but I have a prayer to make.
Yes.
There was a direction upon me to file a supplementary affidavit in the second matter,
There are two
by
matters.
which we could not file.
There
Some
are two
miscommunication.
matters.
There are two matters. 1 and 2. Appellate order is same in both the matters, my lord.
You need some
Controlling
time.
authority,
You need some
only 1 week time, not today will suffice me.
The net counsel for the petitioner prays for time to comply the last order. Post on next Monday.
Yes,
Monday. आज क्या Tuesday है?
Tuesday.
Next Tuesday.
I leave.
उनका appearance record करिए Mr. Ravi Prakash. He has no objection to the prayer for adjournment.
Item 2, WPL 6982 of 2017.
दोनों मैटर में
एक ही
appellate
साथ
order
है ना?
same है.
Same हो. Instructions आ गए?
My lord, it is that we had to file a certificate of the bank that we had deposited the amount 62,000 and all.
अच्छा.
That is there with us, my lord. Some miscommunication on my part we will not. I'll file it.
I hope next Tuesday खत्म हो.
Definitely. It is a very small matter.
Item 5, WPL 2530 of 2019.
Who is there for the petitioner? बताइए.
Lord, court below order has been extended, in which relief has been extended to the OP number 2. Management has appealed that order. Appellant's husband died on 24/1/2003.
Just a moment. The notice has been served.
Lord,
RPA through
behalf of
Wakalatnama. You are for the private respondent.
for respondent, Kari Devi,
Okay, only respondent.
respondent.
Okay. Yes. Tell us what is the matter. Where is the petitioner? We do not know. You tell us.
Husband of Kari Devi
Expired when?
died on 24th January 2003.
24/1/2003.
3.
Okay. Then
Kari Devi was not having any male child. She was having only girl child. So she applied for compassionate appointment to his son-in-law. अपने दामाद के लिए अप्लाई किया. Management turned
बेटी
down.
थी.
Lordship,
Daughter
बेटी थी.
She had a daughter.
She had a daughter. Kari
Then-
Devi applied for compassionate
For
appointment
son-in-law.
to his son-in-law.
Okay.
Her claim was rejected by management, so he preferred an writ application before this honorable court.
Okay.
Void 413
Did
2006.
WPS number?
413 2006.
CWJC होगा उस समय कि WPS?
WPS
431 of
413 of 2006.
sorry.
Which was decided
413 of 2006.
6.
Which
was
was?
decided on 10/5/2006.
10506. Saying what?
06. Holding that.
Where is that
coming the
order?
order should also.
Where is that order? Where is the order?
Holding that lordship, somewhere in the writ petition, Kari Devi stated that I am fully dependent on my son-in-law. Court hold that when you are fully dependent on your son-in-law, then son-in-law doesn't need compassionate appointment.
Rightly so.
So you are eligible for monetary compensation.
Fair enough.
Lordship, this is 413
Yes.
2006.
So,
So after that, lordship,
Then what
she
happened?
applied.
Then she applied for monetary
Order was holding that.
she applied for monetary compensation.
Order was in 413. It was hold that you will get monetary compensation.
Get मतलब ऐसा कोई finding तो नहीं होता है. But if there was any finding, then why did you go to the labor court?
Respondent did not took any action on this. I was
Last page I don't have of this order.
In the order sheet also.
Lordship, this is last question.
Then what happened?
No
You filed a
action
petition
was
under
taken
section
by the management. She
33C2.
preferred an application before the tribunal.
Threatening the age of 60 years. She filed an ID case for payment of due from the date of death of the petitioner, the workman, till date of when the
Before
application
tribunal,
was
the
filed.
impugn order was passed, holding that your husband had died on 24/1/2003, and your writ application was decided on 2006. So you will get monetary compensation from 2006 onwards. Till you attain the
49
age of
Yes.
60 years.
Yes.
Lordship, I have to say something.
And with simple interest at the rate of 6% per annum.
Lordship, I have to say something. Lordship, management has issued one little memo, which has not come very fair also, but I have got one copy.
देखिए इस तरह से हम ये सब नहीं देखते लेबर मैटर
Fair copy नहीं.
फेयर अनफेयर का बात ही नहीं है पॉकेट से निकाल के डॉक्यूमेंट मत लेबर मैटर में दिखा unless it is an order. What is your case? Why have you challenged this order?
For the interest, interest of 6% has been levied upon the respondents in the BCCL.
इंटरेस्ट देने का कोई पावर नहीं है अंडर एनसीडब्ल्यू ये सिर्फ इंटरेस्ट पे बोल रहे हैं बोलते हैं अंडर द प्रोविजन ऑफ एनसीडब्ल्यू देयर इज नो पावर टू ग्रांट इंटरेस्ट व्हाट डू यू हैव टू से आई पास वन जजमेंट आल्सो ऑन दिस वेयर इज दैट हैज अटेन फाइनलिटी
लॉर्डशिप, इसमें और भी कुछ थोड़ा कहना है.
अभी सुनिए ना आप ये किसी चीज से एग्रीव नहीं है सिर्फ इंटरेस्ट पोर्शन से एग्रीव
लॉर्डशिप, मैनेजमेंट का ये खुद का है कि ये डेट ऑफ एप्लीकेशन और डेट ऑफ डेथ से देना है मॉनेटरी कंपनसेशन.
तो
Our issue is also that it will be applicable.
डेट ऑफ डेथ से देना है लॉर्डशिप, कहीं एप्लीकेशन और कहीं ये उस पे कहीं कोई डिस्प्यूट ही नहीं है, इनका खुद का रिजोल्यूशन फ्रॉम डेट ऑफ डेथ देना है और उसका जजमेंट लॉर्डशिप हमारे ऑनरेबल हाई कोर्ट का कि फ्रॉम डेट ऑफ डेथ देना है विथ इंटरेस्ट देना है.
नहीं आप हमको ये बताइए ये अवार्ड तो आपने नहीं चैलेंज किया है ना हैव यू चैलेंज दिस अवार्ड नो हैव यू चैलेंज दिस अवार्ड नो they have given the impugned order has given from June 2006 to 4/9/2011 right therefore and his only grievance is that interest could not have been awarded and this order is covered this issue is covered by an order passed by this court this has can become final दिखाई जरा इसका स्टेटस देखिए WPL number 6969 of 2017
Lordship, whatever I know that your lordships have power under 226 to extend any relief in favor of the
आपको ऐसा लगता है लेकिन इतना पावर हम लोग को कॉन्स्टिट्यूशन ने नहीं दिया है कि बियॉन्ड लॉ हम लोग जाके आपको रिलीफ दें.
लॉर्डशिप ये है डेट ऑफ डेथ से देना है उनको, ये मैनेजमेंट अपने
आपको बात ही नहीं समझ आ रही है आपने तो अवार्ड चैलेंज ही नहीं किया है तो अवार्ड आपके फेवर में फर्दर कैसे कर दें अंडर व्हाट प्रोविजन ऑफ लॉ. अभी सुप्रीम कोर्ट का कई सारा ऑर्डर्स आया है डेट ऑफ डेथ से नहीं फ्रॉम 3 years प्रायर टू फाइलिंग ऑफ द केस से दिया है सुप्रीम कोर्ट ने ठीक है ऐसा नहीं होता है क्या बोलना है इंटरेस्ट आप वो छोड़िए
ये है विथ इंटरेस्ट के साथ ये हमारे ऑनरेबल कोर्ट का है
226 में इंटरेस्ट दिया है ना लेबर कोर्ट को पावर है क्या देने का एनसीडब्ल्यूए को जब लेबर कोर्ट एनफोर्स कर रहा है तो 226 में तो डिस्क्रिशनरी पावर है ठीक है बट सो फार एज द एनसीडब्ल्यूए का एनफोर्समेंट जब होगा तो अगर एनसीडब्ल्यूए में जो है सो है उसी के अनुसार चलेगा.
What for compensation is under section 33C2 of ID Act.
एंड 33C2 में कहाँ है कि आपको इंटरेस्ट के साथ अमाउंट मिलेगा नहीं है ना. He's only agreed. This is squarely covered by this judgment.
Yes, ma'am.
लॉर्डशिप मेरे जजमेंट को भी
आप जरूर से एकदम करेंगे. WPL number 2530 of 2019. The learned counsel for the parties are present. The counsel for the petitioner submits that the husband of the petitioner had expired on 24/1/2003 and there was no male child. Consequently, the petitioner had applied for compassionate appointment of her son-in-law, which was rejected by the respondents, and ultimately a writ petition being WPS number 413 of 2006 was filed before this court, and the court, while refusing to allow the prayer for compassionate appointment, observed that at best, if the petitioner widow crossed her age, then she would be entitled to monetary compensation. It was observed that the petitioner widow would get monetary compensation from the respondents. The learned counsel submits that when the amount was not paid, a petition under section 33C(2) was filed before the learned labor court at Dhanbad, which was numbered as MJ case number 1 of 2017.
It was monetary compensation was given to her. After retirement, she paid. She filed this MG case for payment of arrears from the death till the date when application from monetary compensation was approved.
Just just a moment. The claim for monetary compensation was from June 2006 to 4/9/2011 with interest, correct? The learned counsel for the petitioner, while assailing the impugned award, has submitted that the petitioner is only aggrieved by the direction to pay interest.
Yes, but our submission would be that we had a circular order, office order, where it was given in the Annex 3. It has been said that payment of monthly basis will be done from the date of application on when the application will be given for monthly basis.
एकदम
The-
गलत
that
बोल
is
रहे
what-
हैं
Just a moment.
एकदम गलत बोल रहे हैं ऐसे गलत बोल के रिलीफ साहब एकदम डिनाई करते हैं एप्लीकेशन का ही चर्चा नहीं है पैरा नंबर 3 आप पढ़ रहे हैं
Annex 3 में
आप
और-
क्यों इतना एजिटेटेड मत रहिए। उनके
Sorry.
कहने से उनके
Sorry.
जैसा ऑर्डर नहीं बन सकता
सर
ना।
सिमिलर सर
उनका समीक्षण तो लिखाएंगे कि ना लिखाएं।
व्हाट्स पेज 26 एनेक्स 3 एप्लीकेशन का कहीं चर्चा नहीं एक वर्ड नहीं और एप्लीकेशन
देखिए, जो-
डेट ऑफ एप्लीकेशन नोटिस
जो डॉक्यूमेंट लोअर कोर्ट रिकॉर्ड में नहीं रहता है, लेबर मैटर में उसको हम देखते तक नहीं।
सॉरी नोटिस ये पेज 26 है एनेक्स 3 का इसका
अब आप
last-
बैठ जाइए। अब आप बैठ जाइए। The learned counsel has submitted that the petitioner is aggrieved by the award of interest under the provisions of award of interest by the impugned award. He has relied upon a judgment passed by this court in WPL number 6969 of 2017, decided on 19/6/2023. And has referred to paragraph 28 and 29 of the said judgment. He submits that the present case is squarely covered so far as the point on the point of interest is concerned. The learned counsel appearing on behalf of the respondent while opposing the prayer of the petitioner has submitted that has relied upon the judgment passed in WPS number 1019 of 2007, इसमें कहाँ है payment का interest, and has submitted that in the matter of non-payment of monetary compensation under clause 9.5.0, there was a direction to pay interest at the rate of 5%, simple interest at the rate of 5%. By observing that the respondents must pay the statutory interest on the amount of monetary compensation. The Learned Counsel has also relied upon judgment passed in LPA number 657 of 2018 to submit that the monetary compensation is payable from the date of death of the employee. And in the present case, the date of death is 24/1/2003. But by the impugned award, the compensation has been paid from June 2006 to 4/9/2011. After hearing the Learned Counsel for the parties and considering the facts and circumstances of this case, this court finds that it is not in dispute that the husband of the petitioner had expired on 24/1/2003, and at one point of time she was claiming compassionate appointment for her son-in-law, but the same was rejected by the respondents, which was subject matter of challenge in WPS number 413 of 2006. The said writ petition was dismissed by order dated 10th of May 2006. However, it was also observed, by holding that in presence of widow or daughter of deceased employee, the son-in-law is not entitled to compassionate appointment. But an observation was also made that the petitioner widow shall get monetary compensation from the respondents. When the monetary compensation was then thereafter, the petitioner filed MJ case number 1 of 2007 before the Learned Labour Court, being under section 33C2 of Industrial Disputes Act, claiming monetary compensation from June 2006 to 4/9/2011, as apparently the monetary compensation for the prior period was paid. नहीं, claim ही आपका ये था, claiming monetary compensation from June 2006 to 4/2009. The Learned Court after framed an issue as to whether the applicant was entitled for monetary compensation with interest under the provisions of 9.5.0 of NCWA. The Learned Court referred to the provision of 9.5.0 and ultimately granted monetary compensation from June 2006 to 4/9/2011 with simple interest at the rate of 6% per annum, with a further from the date of passing of the order, failing which the petitioner was directed to pay the arrear along with simple interest at the rate of 99%. The issue as to whether the Learned Labour Court was empowered to grant interest under the provisions of section 33C2 fell for consideration in this before this court in WPL number 6969 of 2017, and following decision was passed para 26 to 31. In the aforesaid judgment, this court has held that there is no scope for passing an order for payment of interest over and above whatever was due under the settlement or over and above whatever was due as per the award. If the settlement or this court has also held that the provision of section 33C deals with recovery of money which has already been quantified and if so required capable of being computed by labor court and is in the nature of execution proceedings. In the judgment which has been relied upon by the respondent in WPS number 1019 of 2017 also, this court had observed that the respondents were to pay statutory interest on the amount of monetary compensation. It has also been observed by this court in WPL number 6969 of 2017 that in case the amount computed is sought to be recovered through any certificate proceeding, the statutory interest as applicable to the certificate proceedings would be payable in accordance with law. In such circumstances, the impugned award is set aside to the extent it directs the petitioner to pay interest to the respondent. This petition is accordingly disposed of. एग्जीक्यूशन होगा तो उसमें सर्टिफिकेट प्रोसीडिंग के अनुसार आपको इंटरेस्ट मिलेगा, एग्जीक्यूशन में मिलेगा, अवार्ड में नहीं मिल सकता. ठीक है?
Lordship, extremely sorry. कुछ बताना जरूरी भी चाह रहे हैं और वो अंदर रख रहा है तो परेशानी हो रहा है. अभी लॉर्डशिप का ऑर्डर एक्सटेंड किए, WPS डेट ऑफ बर्थ का मैटर था, एक साल प्री मैच्योर रिटायर कर दिए थे. रिस्पोंडेंट किस तरह से उस ऑर्डर के साथ क्या किए, जस्ट वो फ्रस्ट्रेशन मेरा भी निकल गया है लॉर्डशिप के सामने।
क्या किया रिस्पोंडेंट उसमें?
बोल सकते हैं नहीं बोल
कौन
सकते?
रिस्पोंडेंट है उसमें? प्राइवेट रिस्पोंडेंट है?
नहीं,
स्टेट ने क्या किया?
रिस्पोंडेंट ऑर्डर लेके 1 साल प्री मैच्योर रिटायर किए थे।
तो क्या किया रिस्पोंडेंट?
उसको उसका एरियर्स को कैलकुलेट करना था।
तो अब दूसरे केस का कहानी इसमें क्यों ला रहे हैं? प्री मेच्योर रिटायरमेंट अगर होता है तो हम तो कॉन्सिक्वेंशियल रिलीफ देते ही नहीं।
हाँ मिला।
हाँ तो बस मिल गया, बात खत्म हो गई।
रिस्पोंडेंट 5000 कम उसका पेंशन डिसाइड किए और बोले कि तुम ले लो, कंप्रोमाइज करो, नहीं तो हम लोग
अपील करें तो करना ही चाहिए ना, सुप्रीम
अपील
कोर्ट
कर
तक
दिया,
जाना
अभी
चाहिए।
pending
हाई कोर्ट
है।
का आपने, मेरा तो ऑर्डर सुप्रीम कोर्ट तक नहीं जा रहा, हम तो चाहते सब चला जाए। अगर भाई कोई ऑर्डर स्टेट या कोई भी ऑर्डर हुआ है तो या तो कंप्लाई करिए या चैलेंज करिए, तीसरा कोई उपाय है क्या? नहीं है ना। कोर्ट के ऑर्डर को या तो आप कंप्लाई करिए या चैलेंज करिए।
लॉर्डशिप उस रेट में मेरे पिटिशनर के फेवर में एक्सटेंड रिलीफ फॉर लॉर्डशिप वेरी मच ऑब्लिक, लेकिन व्हाट सेंसिटिव व्हाट फॉर द ऑर्डर रिस्पोंडेंट इज हैविंग, उसका फ्रस्ट्रेशन अभी थोड़ा सा निकल गया। एक्सट्रीमली सॉरी।
आप स्टेट का फ्रस्ट्रेशन मेरे कोर्ट पे क्यों आप बात कर? और इस तरह से ना किसी से कुछ बोलने का कोई काम नहीं है, ठीक है? ऑर्डर किए हैं उन्होंने, कंप्लाई किया होगा, नहीं किया है तो कंटेम्प्ट फाइल करिए, वो भी दूसरा कोर्ट में लगेगा, मेरे कोर्ट में नहीं लगेगा।
कर दिया कंटेम्प्ट लॉर्डशिप, नहीं कर रहा।
मेरे कोर्ट में नहीं आएगा कंटेम्प्ट, दूसरे कोर्ट में जाता है।
हम सप्लीमेंट्री फॉर दिस फिक्स केस आइटम 3 क्रिमिनल डिवीजन 742 of 2023।
बताइए। सीआरपीसी दीजिए। पहले आप बताइए, वो तो रिस्पोंडेंट है ना, आप तो आर्ग्यू करिए।
जी, so the order is at page 37. The order of 80% may read
Yes.
page 38% may contain. From careful examination of judicial record, it transpired that the complainant was examined on essay and asserted the facts alleged therein in the complaint petition. CW1, namely Arvind Tiwari, was also examined and stated the fact alleged in the complaint petition. CW2, namely Jitendra Nath Tiwari, was also examined and stated the fact alleged in the complaint petition as stated above.
पेज 37 पढ़े थे ना?
Page 37 से start, operative person.
हाँ ठीक है।
Yes, sir. Second paragraph. The
Yes.
court, wide order dated 24/2/2023, had directed the officer in charge, Radilla PS, to conduct the investigation in terms of section 2021 CRPC 1973 and submit report therefore in light of judgment of the Honorable Supreme Court in case of Mohammad Yusuf versus Afaq Zahan and Manju Surana versus Anil Arora. The officer in charge, Radilla PS, has submitted the investigation report wide number 540/23 dated 6/4/2023, which was called for wide memo number 362 dated 25/2/2023.
Yes, I've read it. क्या बोल रहे हैं?
Proceed may kindly see the PW2 as CW2 form. CW2 is an eyewitness to the entire occurrence. Page 33.
Yes.
यह केस अर्चना तिवारी ने सरिता सिन्हा, प्रणव दासगुप्ता, राम उदय कुमार शुक्ला जी पर दायर किया है। घटना दिनांक 15/7/2022 को दोपहर 3 बजे की है। मैं डीपीएसओ की गेट के पास खड़ा था तो देखा कि सरिता सिन्हा
Fully
ने
supported.
जी
यही तो।
जी
और-
now the only ground on which my entire complaint has been dismissed is the CDR report given by the police officer. Now, so may kindly see for the CDR report. Placing on judgment. The CDR report is not a substantive evidence, rather it has to be proved. Relevant is page 41, para 16.1.
Para 16 point.
Page, internal page 41, down the page.
Yes.
The convicting court also relied on CDR exhibit PW17B in respect of civil non-citizen, which as per the CF exhibit PW17A was issued in the name of appellant Azad Ilyas Gaurav to establish his presence at the spot. The convicting court also relied on CDR, exhibit PW17/E in respect of scene number such and such, which as per CF exhibit PW17D was issued in the name of convict Kanhaiya Jha to establish his presence at the spot. CDR data may be an important and effective piece of evidence which may facilitate and assist court in ascertaining the presence of different participants in commission of an offence, including the complainant, and proposed accused at one particular place or location which may be their presence at or near the place of occurrence. However, CDR data can only be taken as supporting or corroborative piece of evidence, and conviction cannot be made solely on basis of the CDR data. Now, see, here I pose it. The CDR report has to be proved by the other side. Now, in this present case, is being said that my tower location was not at the place of occurrence. Rather, my tower location was, it is not necessarily where I was, but it is being said that I was not present at the place of occurrence. Whereas the evidences shows that I was there, so the eyewitnesses are there, and this particular PWP2 has not been discussed. It is only been said that he has supported the fact of the present case. And so far, what the report has come, that has to be tested and proved by the prosecution or by the defense in either ways. Now, if this complaint is not allowed to be proceeded with, then it will cause prejudice. Let's say for the moment, let's say complaint person, we can see what I have made in the allegation in the complaint. Based on
I've seen it. I've seen it.
and so far the other one judgment I'm seeing also. The 24 Supreme Court. Para 53, page 115.
Yes. Yes.
Para 53 also. We note that in a different context, this court is National Bank of Oman versus Barakara Abdul Aziz, summed up the duty of a magistrate as follows. 9. The duty of a magistrate receiving a complaint is set out in section 202 of CRPC, and there is an obligation on the magistrate to find out if there is any matter which calls for investigation by a criminal court. The scope of inquiry under this section is restricted only to find out the truth or otherwise of the allegations made in the complaint in order to determine whether process has to be issued or not. Investigation under section 202 CRPC is different from the investigation contemplated in section 156, as it is only for holding the magistrate to decide whether or not there is a sufficient ground for him to proceed further. The scope of inquiry under section 202 CRPC is therefore limited to the ascertainment of truth or falsehood of the allegation made in the complaint. First, on the material placed by the complainant before the court. Second, for the limited purpose of finding out whether a prima facie case is for issue of process has been made out. And third, for deciding the question purely from the point of view of the complainant without at all adverting to any defense that the accused may have.
Yes, what do you have to say?
Now, from this judgment, my lords, my work has become easier. Now, the court has to discover the truth or falsehood made in the complaint. So far, investigation which was given under section 202(1), that is the domain of the magistrate. That provision is there in the in section 202. Now the magistrate has to look into whether there is sufficient grounds for proceeding against the accused persons or not. The report is with the record, my lords, if your lordships may kindly have a look through. It is not the case that on the basis of only tower location, the complaint has been dismissed. Lords, the investigation has been made. If your lordships may kindly have a look to the report. Tower location is one of the grounds. report is dated 6/4/2023.
CW2 का नाम क्या है? What is the name of CW?
Yes.
Jitendra Tiwari.
Jitendra Tiwari.
Yes, पढ़िए रिपोर्ट में क्या ऐसा है?
No,
क्या
Your
क्या
Lordship.
चीज़ है आपके?
6/4/23.
Yes.
I am reading from second paragraph notes. अनुसंधान के क्रम में इस वाद के घटना स्थल सराय ढेला थाना अंतर्गत जगजीवन नगर, दिस एड्रेस इज वेरी रेलेवेंट, स्थित दिल्ली पब्लिक स्कूल का न्यू प्राइमरी / जूनियर विंग का निर्माणाधीन भवन के गेट का निरीक्षण किया, जो सराय ढेला थाना से पूरब के दिशा में महज 250 मीटर की दूरी पर स्थित है। निर्माणाधीन भवन के गेट के आसपास कोई भी सीसीटीवी कैमरा संधारित नहीं है, जिसके आधार पर घटना की पुष्टि हो सके। वहां पर उपस्थित गार्ड प्रकाश महतो उम्र 40 वर्ष, पिता सोएल्सो से घटना के संबंध में पूछताछ करने पर उनके द्वारा बताया गया कि जब से इस बिल्डिंग का निर्माण कार्य शुरू हुआ है, तब से मैं यहाँ गार्ड के रूप में काम कर रहा हूँ तथा दिनांक 15/7/22 को यहाँ पर इस तरह का कोई घटना नहीं हुआ। यह घटना स्थल थाना से महज 250 मीटर की दूरी एवं पुलिस अधीक्षक नगर एवं पुलिस अधीक्षक ग्रामीण धनबाद के आवास से महज 100 मीटर की दूरी पर स्थित है। अगल बगल एवं गुप्त रूप से पता करने पर भी घटना का कोई पुष्टि नहीं हो पाया। इस वाद में घटना की तिथि दिनांक 15/7/22 के अपराह्न 3 बजे का बताया गया है। उस दिन का थाना दैनिकी एवं थाना में प्राप्त सभी शिकायत पंजी का अवलोकन किया, परंतु इस घटना से संबंधित कोई भी शिकायत सराय ढेला थाना में नहीं दिया गया है। उस समय के तत्कालीन पुलिस निरीक्षक सह थाना प्रभारी श्री वीर कुमार जी के मोबाइल फोन पर संपर्क कर इस घटना के संबंध में पूछा गया, परंतु उनके द्वारा बताया गया कि इस तरह की घटना का उन्हें कोई भी सूचना प्राप्त नहीं हुआ। Then I am coming to Lord's next page. Second paragraph. Of the said report. इस वाद में वादनी एवं वादनी के पिता एवं तथा उपरोक्त चारों अभियुक्तों का मोबाइल नंबर ज्ञात किया गया, जिसमें वादनी अर्चना तिवारी दी कंप्लेनेंट्स नंबर मोबाइल नंबर सोएल्सो, वादनी के पिता अरविंद तिवारी ही CW1 का मोबाइल नंबर सोएल्सो तथा अभियुक्त सरिता सिन्हा, मिलॉर्ड्स वी आर नॉट कंसर्न विद अभियुक्त का मोबाइल नंबर्स। देन आई एम स्किपिंग 4-5 लाइन्स। प्राप्त रिपोर्ट के अवलोकन से ज्ञात होता है, हैव योर लॉर्डशिप्स गॉट इट इन द सेम पैराग्राफ, कि वादनी अर्चना तिवारी का मोबाइल नंबर सोएल्सो का टावर लोकेशन घटना की तिथि 15/7/23 को समय 11 बजे दिन तक साहिल अपार्टमेंट कार्मिक नगर है तथा घटना के समय 15 बजे का टावर लोकेशन नारायणपुर पिपरा बेरा कोयला नगर है। The place of occurrence is different, milords, which I have already shown in the preceding paragraph. वादनी के पिता का मोबाइल नंबर सोएल्सो का टावर लोकेशन 14.54 एवं 15.6 बजे का टावर लोकेशन नारायणपुर पिपरा बेरा कोयला नगर है। साथ ही सभी अभियुक्त गण का टावर लोकेशन भी अलग अलग है। प्राप्त CDR टावर लोकेशन एवं SDR की प्रति साथ संलग्न की जा रही है। The CDR is annexed with the report. The place of occurrence is Jagjeevan Nagar.
Yes, we have known.
Now, your lordships may kindly then come to the last but one paragraph, 7 lines from the bottom. इनको आगे बयान में पूछा गया, have your lordships. अर्चना तिवारी दी कंप्लेनेंट, इनको पूछा गया, इनको आगे बयान में पूछा गया कि आपके द्वारा थाना में या किसी वरीय पुलिस पदाधिकारी के पास इस संबंध में कोई लिखित शिकायत किया गया है, तो उनके द्वारा बताया गया कि हमारे द्वारा कोई लिखित शिकायत थाने में या कोई वरीय पुलिस पदाधिकारी के पास नहीं दिया गया है। दिस इज द स्टेटमेंट ऑफ द कंप्लेनेंट made before the police officer who was investigating the matter under section 202(1) of the CRPC.
ये आपने वादिनी से पूछा.
Vadini se पूछा. So she says that she has not made any complaint before the police or any superior officers of the police. Now your lordships may kindly come to the complaint petition. What her averment is in the complaint petition. Paragraph 4 of the
You
complaint.
just tell us one thing. While passing the impugned order, whatever you are arguing, you are supplementing to whatever reasons has been given in the impugned order. Impugned order is referring to this report
Yes.
and picking up only the CDR report,
No.
right?
Entire report.
Just a moment.
The
And has totally omitted consideration of CW2 and the CW1, the father of the petitioner had deposed before the court that he was the one who went to Thana for the purposes of registering FIR. No such question has been put to him. You had
No,
put
no.
this question
It
only
is,
to...
no, it is the complainant statement also.
No,
If
you
your
just
if your
come
lordship,
to page number 32.
first your lordships may kindly come to the statement of the complainant on solemn affirmation. Paragraph 4, page 31, annexure 2. Paragraph 4. इस घटना की सूचना मैंने BCCL अधिकारी एवं सराय ढेला थाना को दिया, लेकिन उनके खिलाफ कोई कार्रवाई नहीं की गई, इसलिए मैंने कोर्ट में केस किया. It is the statement of the complainant that she has given information.
Now
that
there are two statements. One is before the court, the other is recorded by the police, right?
Yes.
Now she has to be confronted with all this. But so far as
No.
issuance of process is concerned,
Yes,
that is
at the
sufficient.
time of issuance of process, then the entire investigation made under section 202 will become redundant. Because if the person comes and he speaks something else, which is contrary to the investigation made by the police officer
was any written statement taken in writing by the police? You see, her statement is being recorded by the police in the form of a report, right?
Whose statement?
The statement of the complainant. Where was the scope for recording any further
Not
statement when the complainant is already deposing before the court in support of her complaint?
Not
The
what?
police was not supposed to again go and conduct an investigation with respect to and ask every person. There was
That has been done. That has been done by the police. Even all the complainant, her father, they were inquired by the police. Other persons, the guard and other persons of the vicinity,
Then
they
what
have been
is the
examined.
difference? What is the
What-
difference between an investigation conducted by police under section 156 and an investigation conducted by the police under section 202 with subsection 2?
Lord,
Is there
is
any difference or there is no difference?
There is difference.
What is the
because under the investigation made under 156 is that can be form basis for submitting a charge sheet or final forms. Here it is an aid to the magistrate.
That's right.
This inquiry report is an aid to the
That's
magistrate.
right. Therefore, the evidence, whatever has been recorded through essay and through the deposition before the court at the time prior to issuance of process, is not nullified by any statement contrary given to the police by any of the witnesses.
Like,
Bataiye.
the magistrate has to see the truthfulness of the complaint.
Magistrate is recording the statement.
नहीं।
आप ऐसा चीज मत हमसे कराइए कि लोग हमारी मजाक बना.
नहीं, हम ऐसा चीज कराएंगे भी नहीं.
ऐसा मत
We
करो.
want that the law should be as
Yes.
per the law.
Certainly.
The
आप
judgment.
हमको एक बात
नहीं,
बताइए.
मेरी बात 2 मिनट सुनिए. The judgment which has been cited by my learned friend.
You forget about the judgment.
नहीं,
See the section.
powers of the magistrate has been given. That has been recorded by Honorable Supreme Court. What
Yes.
are the powers of the magistrate? He has to find out the truthfulness of the complaint. if a person comes
He has
making an allegation and records her statement as per the complaint, how could the magistrate apply its judicial mind to find out truthfulness? And for that, he has sought inquiry by the police, the investigation by the police. The report is there, that has to be looked into. Why I am submitting this? The complainant has made false statement in her solemn affirmation as well as in the complaint petition. That is what I am trying to show. If your lordships may kindly have a look to the complaint petition, she has made specific averment in the complaint on oath कि उपरोक्त घटना की सूचना बीसीसीएल कंपनी के सेक्रेटरी सो एंड सो एवं सरायढेला थाना से शिकायत की. She has made such a statement on oath in the complaint. Thereafter,
after that बोल रहे हैं.
हाँ, कोई कार्रवाई नहीं की.
अभियुक्त के विरुद्ध आज तक
अगर कोई जाए और थाना में ना एंट्री करे ना एफआईआर ले तो क्या करे आदमी?
The statement of that police officer has also been recorded by the investigating officer under 202. He says that no such complaint.
So the complainant has a right to cross-examine that person.
No,
Why not?
Not at this stage.
So, therefore, not at this stage. That will be at the stage of trial.
This statement. If your lordships go by that principle, all those statements which are recorded by the police under investigation, that is not cross-examined, then the court should not look those evidences. If that principle is taken into account, Lords, at this stage, the magistrate was duty-bound to find out the truthfulness and see whether there was ample sufficient grounds for proceeding. He has applied its.
Does the section say that the truthfulness of the complaint is to be examined when this matter is referred to magistrate? Let us see. The matter was referred to magistrate under 202 subsection 2. Kindly place 202 subsection 2.
The discretion is with the magistrate. Any magistrate, on receipt of a complaint of an offence of which he is authorized to take cognizance or which has been made over to him under section 192, may, if he thinks fit, I am skipping this because it is for the persons who are residing outside the, postpone the issue of process against the accused and either inquire into the case himself or direct an investigation to be made by a police officer or by such other person as he thinks fit for the purpose of deciding whether or not there is sufficient ground for proceeding. This is the discretion of the court. He, after making an investigation through police officer, he has to decide whether there is sufficient grounds for proceeding further. And only, Milords, the barred statement has not to be taken into account. The statement made by the complainant in her complaint, under solemn affirmation, the statement of the witnesses, this was inquired into by the police officer.
The court recorded the solemn affirmation and also recorded evidence of 2 witnesses. And thereafter the court had asked for investigation.
Thereafter the court has fixed for the cognizance, for the order on the point of cognizance for 3 occasions. On the 3rd occasion, Your Lordship, court has decided for further investigation.
Okay.
3 occasions, Your Lordship, on
So
8.
that would, if there is a further investigation, will it wipe out further investigation in the sense when the matter is referred?
This word further investigation,
let's forget
it is a part of inquiry. It is not a further
That's
investigation.
Right. It's a part of
it is
inquiry.
A part
For
of
further
inquiry. Yes,
inquiry.
further inquiry.
Does the further inquiry wipe out whatever has already been recorded? Does it wipe out?
Yes, for the reason,
No.
from the inquiry report, if your lordships may kindly have a look to the inquiry report, they have made a statement before the police officer also. They have made a statement before the court also. Both are totally in contradiction to each other.
So,
Thereby meaning, and the statement made before
So
the
there-
police officer that they have not lodged any police report, they have not made any complaint to the police. That has been verified from the concerned police officer, from the concerned police station, and that was found to be true. Thereby
so
meaning
if there
the
is,
statement
if there
made.
is no entry made in the police station
It
regarding
was not-
filing of complaint, then under such circumstances, it has to be assumed that nobody went to the police station to file.
No, it was not only that no entry was made. The concerned officer in charge at that point of time was also asked about the any complaint.
Therefore,
Because your lordships may kindly appreciate
at the time
the-
of inquiry, preparing this inquiry report, did this person who was conducting the inquiry mentioned about any CDR report qua the complainant and the officer in charge of the police station, and say that they never went to the police station also? Is there any such inquiry? No.
No, yes, if your lordships may kindly
That
have
they
a look
never
at
went
the,
to the police station.
if your lordships may kindly have,
And
नहीं वो हम दिखा
even
देते हैं
if-
CDR
even if
report.
CDR report देखिए आपकी
CDR
बात से हम
report
convince
is
नहीं हैं।
annexed with the inquiry report.
अच्छा,
Let's see
सुनिए।
their tower location, whether
हम
they have
सुनिए।
gone to the police station or
कुछ तो
not.
डिसाइड करेंगे ना। चलिए, आपको क्या बोलना है बताइए।
The police have acted as per the directions of the honorable court. Now we
Where
found,
is that direction by which? Where is that direction? Order कहाँ है वो?
Yes.
दिखाइए तो।
ये कोड
Page
क्या हुआ है?
34.
Page
कोड क्या
34.
हुआ है?
Annexure 3. And इसमें एक फैक्ट है, इसीलिए LCR मांगा गया था. Prior to this order dated 24/2/2023, there are two others orders. Those orders are, those are order dated 8/12/2022. Last witness has been examined, that is CW, on 14th November 2022. After that, case was fixed for hearing on cognizance. That was on 14/11/2022. 8/12/2022, the matter was taken up. The order was complaint file attendance through lawyer. On call, learned lawyer for the complaint appeared. Heard on cognizance point, fixed 7/1/2023 for order. Again, the matter was taken up on 7/1/2023. Today, learned lawyers absent themselves from the court works. Complaint takes no step. Order is there. It fixed such and such for hearing on cognizance point. Third, 23/1/2023. Complainant file attendance through lawyer on call. None appear on none appear. Fixed 7/2/2023 for hearing on cognizance point. Again, 7/2/2023, complaint file attendance through lawyer, call for lawyer for compliance, appeared, heard on cognizance point, fixed for 24/12/2023. Four orders. The matter was fixed for order, that is on the point of cognizance. I don't know what was the reason, Your Lordship, the 24/2/2023, the learned court has sent this matter, that is under section 202(1). For further investigation.
Before coming to the state, I just want to know from you, in a case where the statement of the witnesses has been recorded and the matter is sent for investigation after recording a few statements, and there is a contradictory statement or contradictory fact comes, does it wipe out
No,
the
not at all.
statement which has
Even
already
Your Lordship,
been
I can
recorded?
see if the final form has been submitted in the cases, 156(3) giving my ample power to the police. If the police has submitted the final form, even we are filing protest complaint, and only on our statement the court is taking the cognizance. Normally, here Your Lordship, the same thing has been done prior to that. On oath, Your Lordship, the statement has been recorded. They have stated repeatedly before the court that the police is not cooperating, so that we came before this court, and so that we have stated before the court on oath that these are the occurrences which has been committed. It is not a case of simple assault. It is a case of 354 also, and that has been alleged against the other person. The police, again the matter sent to the police, that is to by the court. Reason no, I don't know why. After 4 days of adjournment, the case has been sent to the police. Police has recorded the statement of one Chowkidar, who is the employee of the accused persons. A statement of the Chowkidar has been recorded. They are saying that the Chowkidar has said that no such occurrence was taken place. He is the employee of the accused person. Second, my phone call or the lordship, if my statement has been recorded by the police, in which I have stated something to the police, my statement should have been signed by me. Even 161, 162, your lordship, that is the requirement. That they have not done. Subsequently, a report has.
नहीं
Subsequently,
this statement that 161 statement should be signed.
हम नहीं सुने वो.
It is not
हमको
signed.
सुनाई नहीं दिया.
Subsequently, the statement has been given and the report has been submitted. It was
161 का statement and the statement which has been taken on oath in the court. If there is a contradiction, then do you want to say that statement which has been recorded on oath will be wiped out?
No, not at all. That has the value.
Show me
let
this.
me
I
ask.
will give you the order in your favor. Show me that this will. नहीं आप हो गया. हाँ बोलिए आपको क्या बोलना है?
एक बार पेज नंबर 35 देखा जाए.
35 हाँ क्या है बोलिए.
Middle paragraph, from carefully examination of judicial record. It transpired that the complaint was examined herself on essay and also examined to inquiry witness in support of her case.
That's right.
The officer in charge is directed to conduct thorough investigation of this complaint with help of solicitor in light of section 2021. So, Lordship, subsequently, we have submitted the report. Now, Lordship, apart from the investigation into the place of occurrence, we have collected CDR report of not only the complainant, her father, but also all the 4 accused persons. There has to be some point कि कहीं कोई मिलेगा, कोई नहीं मिल रहा है. All persons, normal case में normally.
एक बात बताइए. कोई ऐसा लॉ है?
Under 65B
आपसे पूछ रहे हैं हम. कोई ऐसा लॉ है क्या कि जो भी आदमी जाएगा क्राइम करने अपने साथ मोबाइल लेके जाएगा? Is there any such law?
There is no law, but
therefore, for the purposes of issuance of process only, right? For the purposes of issuance of process, only mobile location cannot be a conclusive proof that the person was not there.
This is not only on the basis of the mobile location.
Only on the basis of mobile location, right? And so far as the evidence of Chowkidar etc. is concerned, right?
हम इसमें पढ़ रहे हैं जो नीचे कोर्ट का जो ऑर्डर था लास्ट लाइन.
Victim is there who is making a statement.
My lords, and there's a relationship of employee between the victim and the accused persons.
उससे कोई मतलब
नहीं, हम बस वो इसलिए बता दे रहे हैं.
इससे कोई रेलेवेंस नहीं है.
नहीं, रेलेवेंस इसलिए हो जा रहा है लॉर्डशिप फॉर द लिमिटेड पर्पस कि एज पर द इंक्वायरी आल्सो एंड एज पर हर ओन स्टेटमेंट कि जिस दिन डेट ऑफ ऑकरेंस है दैट वाज द लास्ट डे ऑफ जॉब एंड पूरा अमाउंट उस दिन तक का उसको दिया गया था.
सुनिए, इस सब कहानी हम सुन नहीं सकते हैं.
नहीं लॉर्डशिप,
इस प्रोसीडिंग में और इन सब बातों को करके आप हमारे मन को प्रेजुडिस करने का प्रयास भी ना करें, क्योंकि उससे कोई फायदा नहीं होने वाला.
The thing is, the only thing which has to be decided by this honorable court, what evidences has to be looked into by the magistrate for proceeding further.
Yes.
There are 2 reports. Now, my lords, one of either the report is false or the statement made by the complainant is false. Now, it is the discretion of the magistrate to look into the veracity and then to pass an order either to proceed or to dismiss the complaint. The magistrate has applied his judicial mind and taking into account the reports.
Has the magistrate in the impugned order recorded that the statement of the witnesses who deposed before the court is contradictory? Has he recorded that? No. He has not said that it is contradictory and therefore I will accept the report and not the statement of the witnesses who have deposed before the court.
Now, Your Lordships, what he has recorded, that is mentioned.
Yes.
As per the report on the mobile tower location, inspection of place of occurrence, as well as investigation in and around the place of occurrence. All these things have been taken into account by the magistrate. Now only point is हम उसी पे आ रहे हैं, उसी पे हम आ रहे हैं.
कोई फायदा नहीं होगा.
हम उसी पे आ रहे हैं कि elaborate नहीं है, but the entire report is
elaborate क्या? Rather आप जरा देखिए on the analysis of complaint petition, statement of complaint, complainant on SA, the statement of inquiry witness, right? He considers the statement of inquiry witness, C1 and C2 and the investigation report. इसका क्या मतलब है? ऐसा लग रहा है ये ऑर्डर देख के कि सभी ने मिलके बोला है कि कोई केस नहीं बनता है।
नहीं
ऐसा ही
सब कुछ देखते हुए
सब कुछ
the entire record has been seen by the magistrate and after applying his judicial mind
ऐसा
he has come
ऑर्डर
to
में
the
नहीं रिफ्लेक्ट
conclusion
कर रहा है, ऐसा ऑर्डर में नहीं रिफ्लेक्ट कर रहा है।
सिर्फ अब एक चीज ऐड करना चाहते हैं रिपोर्ट का जो मिडिल पैराग्राफ, इट इज नॉट द केस दैट द मोबाइल वाज स्टैटिक,
it was moving and the calls were made every
in and out
minute
call, SMS was also there, in and out call, so it is not the case कि
कि
मोबाइल
कहीं
was
घर पे छोड़ के चले आए।
It is not the
These
case.
are the
प्रूव
defense.
करेंगे या
CDR में आया हुआ है, these are CDR
तो
reports.
क्या करें हम आपके CDR रिपोर्ट का?
डॉक्टर CDR
65B का आप वो सर्टिफिकेट
दिया हुआ था, 65B दिया हुआ
अरे
था।
these are the defense. These are the defense which has to be tested.
क्रॉस एग्जामिन होगा ना?
वही एक
जजमेंट
जजमेंट
का नहीं, इंक्वायरी स्टेज में क्रॉस एग्जामिनेशन नहीं होगा।
नहीं नहीं
इसीलिए
इसीलिए
तो
ना
trial
ट्रायल
के
का
लिए
स्टेज में
करता
होगा।
ट्रायल के स्टेज में तो डिफरेंट एविडेंस आएगा, प्री चार्ज स्टेज पे डिफरेंट एविडेंस आएगा,
एक छोटा
but
सा
at this stage only the sufficient ground has to be taken for proceeding against the accused.
एक छोटा सा जजमेंट साइड
That is the limited aspect.
सीयूजी सिंह दैट इज योर में पैराग्राफ 18 एंड 19 दो पैराग्राफ है, ये जितना ग्राउंड ले रहे हैं दोज आर देयर डिफेंस दैट कैन बी टेस्टेड। 2010 वॉल्यूम 7 एससीसी 578 पैराग्राफ
वॉल्यूम 7
एससीसी 578
578
पैरा 18 and 19 कि what are the court has decided what are the prima facie case and what are the defenses which are available to
इसका
the
जरा
accused.
प्रिंट दीजिएगा 2010 का 7
We are not taking any defense. We are assailing the order. The court has to look into the order. Order क्या हुआ हम उतना ही
पता
बोल
चल
रहे
रहा
हैं.
है
We
कि
are not
पुलिस इज वेरी पावरफुल।
always.
इसीलिए
Always.
that was known to the legislature, इसीलिए ये बेनिफिट दिया गया है हम लोग को कि we can file complaint before the court.
But the court has to look into the vexatious complaint also.
आप लोग छोटा नोट फाइल करिए।
हाँ ठीक है।
Arguments concluded. Post this case for dictation on Thursday. कल फाइल कर दीजिए, छोटा नोट बनाना ज़्यादा करना। चलिए, हो गया? आप लोग का मेंशन क्या हुआ, केस नहीं हुआ टेका?
और एक मेरा मैडम ये ऑर्डर में फर्स्ट केस है आइटम नंबर 24 जिसमें ज्वाइंट कंप्रोमाइज हो गया है।
ऑर्डर्स में
हाँ ऑर्डर में पहला केस है।
मेन लिस्ट का।
हाँ इसीलिए मेंशन नहीं किए थे, मेंशन हम नहीं
लाइए अभी कर देते हैं। कहाँ है पार्टी?
अपोजिट पार्टी नहीं है।
हम
तो पेटिशनर हैं इसलिए है।
कल से जितना रिवीजन आज आया था सब टेकअप हो गया, उसमें भी छूट गया।
एक केस
पास ओवर का तो हम जिम्मेवारी ले ही नहीं सकते, आप लोग
उसमें
जिम्मेवार हैं पास ओवर के।
15 से उसमें ये हुजूर हम आइए डाले थे, वकालतनामा डाला है उसमें इन्फॉर्मेंट की तरफ से हस्बैंड है and she is the wife.
कौन है? आप हैं? आप
दोनों
साथ
कौन?
में रहते हैं?
हाँ, एक जॉइंट कंप्रोमाइज डाला।
कहाँ है, दिखाइए तो कौन सा? Criminal Revision Number 1414 of 2023. The learned counsel for the petitioner and opposite party number 2 have jointly submitted that the parties have resolved the dispute and are living together.
Yes,
ये
Your Lordship.
जॉइंट कंप्रोमाइज पिटीशन डाल देंगे एक डेट।
Just living together?
Yes, Your Lord. Para 3 में।
The parties are living together. State कौन है, कहाँ है इसमें? State से रिपोर्ट लेंगे, हम ऐसे नहीं मानने वाले आपका कहाँ कथा कहाँ है, ठीक है?
One IE, Your Lordship, for
And
the
at
contract.
this, the council for they submit that they shall file joint compromise petition. At this, council for the petitioner has submitted that IA number 6411 of 24 has been filed, seeking exemption
Yes.
from surrender.
And one another IE, Your Lordship, for condonation of limitation.
Another petition being IA number 640524 has been filed for condonation of delay of 425 days.
Yes, Your
आपको कोई objection है?
नो
आइए इसको अलाउ कर दीजिए। 6405 of 24 है ना? Counsel for the opposite party number 2 has no objection for prayer for condonation of delay. Considering the aforesaid submissions, the petitioner is exempted from surrendering before the court till the next date of hearing. In the meantime, the parties may file joint compromise petition. कोर्ट में आएंगे?
By way of ideas.
कोर्ट में आएंगे?
Joint compromise यहीं होगा, दोनों काम.
The parties may file joint compromise petition by filing an interlocutory application. Post this case on बताइए कब रख दें?
एक सप्ताह के बाद कोई डेट दीजिए.
सब अपना आइडेंटिटी कार्ड सब लगा के फाइल करिए.
Yes.
बच्चे हैं?
आधार कार्ड के साथ.
बच्चे हैं?
बच्चे.
August for final disposal. ठीक है? क्या रिपोर्ट मंगाए बताइए? साथ में रह रहे हैं कि नहीं?
They are live jointly together or not?
Counsel for the state is also directed to seek instructions and file an affidavit in the present case through the officer in charge of the concerned police station. पुलिस को नहीं भेजना चाहते.
DLS
ये आके
DLS से?
हाँ, वो बेस्ट रहता है.
आके जॉइंट कॉम्प्रोमाइज दे देंगे, दोनों फिजिकली अपेयर हो जाएंगे, आई कार्ड से भी आधार कार्ड से.
इनफैक्ट एक मैटर में बोला गया था कि हस्बैंड इज नॉट मैरिड, तो DLS से मंगवाया तो पता चला कि मैरिड है.
दोनों जो कोर्ट में आके
फिजिकल अपीयरेंस करा देते हैं.
A report be called for from the concerned DLSA with regard to the statement made by the councils that they are living together. इसी घर पे रह रहे हैं ना? पाकुड़, DLSA पाकुड़. रिपोर्ट आने दीजिए. अगला डेट 8 अगस्त.
In the last case, respondent number, opposite party number 5 has already died. रामुदय कुमार.
5 बज गया, थोड़ा हम पे भी तरस. आप लोग का कितना केस बच गया है जो आप लोग करना चाहते हैं बताइए.
आइटम नंबर 18 some 4 times to file sir.
18 तो मेंशन नहीं किए थे आप.
नहीं पासपोर्ट मैटर.
ठीक है.
45 में
एक केस में वो कॉम्प्रोमाइज का था, कितना पैसा जमा करने का, किसका केस था वो?
2 लाख
आप जमा करेंगे कि सरेंडर सर्टिफिकेट?
4 weeks टाइम चाहिए सरेंडर.
23rd तक हम सबको टाइम दिए, 23 जुलाई तक. ठीक है? सीरियल नंबर 18 में सेम ऑर्डर कर दीजिए.
आइटम सीरियल नंबर 45 मेंशन किए थे.
45 हाँ बताइए क्या था उसमें? 45 कल रख दीजिए. और बताइए. देखिए 3 केस मेंशन हुआ है मेरे पास, 45, 59 एंड 34. ये कल आ जाएगा.
24 कल के लिए रख दिया जाता.
24?
हां
24 नहीं आ सकता.
लीडरशिप सीरियल में.
अच्छा ये वो जॉइंट कॉम्प्रोमाइज.
हां जॉइंट कॉम्प्रोमाइज.
ठीक है 24.
34 में जो है एक मेरा ये है लिमिटेशन करना, जो 51 डेज का उसको अलाउ करके ऑलरेडी LCR एक क्रिमिनल डिवीजन नंबर 159.
अरे भाई तो अभी कैसे? कल ऑर्डर करेंगे ना, फाइल में ऑर्डर करना होगा. ये 4 मैटर्स 45, 59, 34 एंड 24, इसको चारों को कल रख दीजिए. ठीक है.
सीरियल नंबर 37.
37 you never mentioned. मेंशन कर.